audit interventions matters, 2015 land acquisition matters. Procedural development.
Another 22 land acquisition matter.
Most reason was audited 61. I'm sorry, madam. Item number 10, target is there. I'm serving the copy to the announcement college.
My lord, my lord, I am in BC, my lord. I am pardon to mention. My lord, item 40 on behalf of Mr. Ashok Mahanti, Senior Counsel. His sister died today morning. May be taken, my lord, 2 weeks after. Interim order continued, my lord. Item 40. My lord, item 40. Mr.
Supplemental list, item number 1.
Thank you, brother. So, we have to explain one matter that all the 5 matters are really clear. Lottery was pleased to issue notice in that case the lottery. Hello. My lord. My lord. Yes. My lord. The matrix of the case is that the residential land of the petitioner along with the other private land of the village board president was acquired for the establishment of industry.
These dates are very relevant.
My lord.
The you see, CORAM notification is made on 6/1/2006.
6, my lord.
Then 6/1 declaration was made in 2007.
16/1/7, my lord.
What was passed on 30/10/2008.
My lord.
And payment was also made to the
Yes, sir. 31/12, my lord.
Purchase was handed over to sponsor.
My lord.
So now we come to the next page. That in the middle portion there is a bold letter.
My lord. So far as the petition is concerned, the extent of land acquired under the LA proceeding by Khata number 103, 161, 224, 377 by 221, and 377 by 260, corresponding to plot number so measuring an area of 2.54 decimal Mauser. So in this case, the father of the petitioner has received the compensation in the name of Krupa Sindhu Sahu, son of so in the year 2010, without any objection. Fine.
That means that compensation has been received.
Fine.
And physical possession has also been taken.
No, man. Physical possession has not been taken.
That you say.
My lord. The
Just that 2020
in the development.
Let's see. 35 of it,
$366.3 per head.
The question which arises whether there is any difference between taking possession under section under the 894 Act and the expression physical possession used in section 24(2). As a matter of fact, what was contemplated under the 894 Act by taking the possession meant only physical possession of the land. Taking over the possession under the 2013 Act always amounts to taking over physical possession of the land. When the state government acquires land and draws up a memorandum of taking possession, that amounts to taking physical possession of the land. Yes. Mine.
Where it is stated that just to read that matrix of the case that the position was handed over 23,012, 16,400 and 45, 2009. Which have been treated. Just be
Mine.
I will continue that part.
Yes. On the large chunk of the property or otherwise which is acquired, the government is not supposed to put some other person or the police force in possession to retain it and start cultivating it till the land is used by it for the purpose for which it has been acquired. The government is not supposed to start residing or to physically occupy it once possession has been taken by drawing the inquest proceedings for obtaining possession thereof. Thereafter, if any further retaining of land or any re-entry is made on the land or someone start cultivation on the open land or start residing in the outhouse, extra, is deemed to be the trespasser on land which is in possession of the state. The possession of the trespasser always injures for the benefit of the real owner, that is the state government in the case.
So the state government draws up the memorandum of taking possession that amounts to physical possession. It does not necessarily mean that you will totally outstate and your house is whatever is there that will be demolished and the police force would come and or from the government side somebody would give it the charge of cultivating the land. Then it will amount to physical possession.
Yes.
That does not mean it is.
My lord.
Now you come to page number paragraph number 70. That is page number 339.
My lord. The court is alleged to the fact that there are a large number of cases where after acquisition land has been handed over to the various corporations, local authorities, acquiring bodies, etc. After depositing compensation for the acquisition, those bodies and authorities have been handed possession of the land. They in turn, after development of such acquired lands, have handed over properties. Third party interests have intervened and now declaration is sought under the cover of section 24(2) to invalidate all such actions. As held by us, section 24 does not intend to cover such cases at all and such gross misuse of the provisions of the law must stop. Title once vested cannot be obliterated without an express legal provision. In any case, even if the landowner's arguments that after possession to in case of non-payment of compensation, the
Go slowly.
my lord,
Just read it once.
my lord. Even if the landowner's argument that after possession to In case of non-payment of compensation, the acquisition would lapse, where for argument's sake we accepted these third-party owners would be deprived of their lands lawfully acquired by them without compensation of any sort. Thus, we have no hesitation to overrule the decision in Bheliscam Commerce and Narmada Bacha Andolan with regard to mode of taking possession. We hold that drawing the Panchanama of taking possession is the mode of taking possession in land acquisition cases. Thereupon, land vests in the state and re-entry or retaining the possession thereafter is unlawful and does not incur for confirming benefits under section 24(2) of the 13 Act.
Conclusion of the report, case number 392 starts in page paragraph number 365, and the most important part case is 360.2.
Minors. Yes, Lord. The word or used in section 24(2) between possession and the compensation has to be read as nor or as and. The deemed lapse of land acquisition proceeding under section 24(2) of the 2013 Act takes place where, due to inaction of the authorities for 5 years or more prior to commencement of the said Act, the possession of the land has not been taken nor compensation has been paid.
Nor compensation has been paid. This is most important.
In other words, in case possession has been taken, compensation has not been paid when there is no lapse.
When there is no lapse.
You
just read one line is very important.
Then there is no lapse.
In case possession has been taken, compensation has
not been paid. Then there is no lapse.
If compensation has been paid, this is your case. Compensation has been paid and possession has
not been taken, then there is no lapse.
Right. So what does it mean by that last line? Last sentence को माने कौन? आपको केस रे compensation payment दिए. है ना? ये जो देखिए जो definition होची physical possession माने कौन? Physical possession does not mean that government should come will drive you out of that and engage somebody cultivate the land. The moment they draw that memorandum, that will be deemed that physical possession has been taken. Right? Once physical possession has been taken in that sense, compensation has been paid, then there is no question of that chapter closes.
Yes.
That means it cannot be done again with that 2013. So that line is very important. Similarly, the compensation has been paid and possession has not been taken. Here, not only compensation has been paid, but possession has been taken because of that interpretation which has been given in the So how do you meet now? You say that under since physical possession has not been taken, even though compensation has been paid, therefore in view of section 20, it should be the rehabilitation benefits should be. But in this case, I think as interpreted by this title in this case, eco development of not only compensation has been paid, but possession has been. So what you are interpreting that you are still residing there, that does not amount. You are now become a trespasser.
That last opinion lordship put that question. Yes, hello. So only
we are likely to rectify our mistake.
No, my lord. Yes, but that is there. But my humble submission would be it's twofold pair. One is section 24(2) and another pair is non-compliance of 2006 scheme. My lord. In view of the MAU under Annex 1, the MAU
How said that it has not been.
Yes, Your Lordship. Annexure 1, Your Lordship, the MAU that is at page 24, page running page 30, Your Lordship, my lord. Yes.
What we know, annexure 6 on that day.
My lord. Yes.
And was one particularly stage 61. Different category for a chief.
Yes.
Particularly what category is
That was the clarification, Lordship. So on that for a Lordship, this judgment is squarely covered. So, so far my claim is concerned, so far this section 24(2) is concerned. সেটা হবনি negative against me, Lordship. That is that. So far the other prayer, Lordship, so far the rehabilitation and resettlement under the scheme of 2006 scheme under annexure 4, Lordship. So I invite your Lordship to first annexure 1, the MAU, Lordship. Memorandum of Understanding between the state government and the OPCX, Lordship, in the page 30, running page 30. The second paragraph, clause G, Your Lordship. General clauses. Page 30. Government of Orissa appreciate that JSPL is fully committed to the proper resettlement and rehabilitation of the project affected households. Accordingly, JSPL will implement a model program in conformity with the Government of Orissa policy for the resettlement and rehabilitation of the household affected by the project, ensuring in the particular their livelihood, security. JSPL will also take appropriate mitigation measures to ensure that local development in the project area is not adversely affected by the industrial and mining activities. As per this condition of clause, Lordship, annexure 4, Lordship, kindly have glance. This is the scheme of the state government 2006 scheme, Lordship. And in that scheme, Lordship, I invite Lordship to clause 4 at page 46, Lordship. My lords. Then the my lords. The clause 4, survey and identification of displaced families. These are the clause A to I, Lordship. The OP6, after taking the land, Lordship, they have to made a survey and identification of displaced families. Those persons, land losers, they have been displaced from the due to the establishment of the year. They have not made any survey and identification till my lord. My lord. My lord. My lord.
There are 8 lines from the bottom. The stipulation for the purpose of compensation of the funds.
My lord.
It is clear to mention ordinarily within 2 months of the publication so and so, a socio-economic survey would be undertaken in the manner decided by the so and so. In the present case, Navakrishna Chaudhary Center for the government of Orissa conducted a field survey for identification of displaced families and prepared the list which was placed before the so and so. After program notification, socio-economic survey was conducted by approved by the government, where the petitioner's name has not been reflected in the master data one. Then come to the next page. On the request of the debtors so regarding approval of list of villages that is stated, then again notified villagers, next paragraph, raised objection to the earlier SES report prepared by Navakrishna Chaudhary Center for Development Studies and requested the inclusion of the names of the letter of cases. So, litigated issues, a tripartite meeting was conducted with the representatives of the affected village, wherein it was decided to conduct a survey to ascertain the and as for this one, so again resurvey was made. Then the joint survey and verification was done by the representatives of the government officials in the presence of the villagers. There in number of villagers, resurvey work be done and finalized except the village one. So because the villages did not cooperate in survey work for the search. Subsequently, agenda note, but how do you say that survey was not
The benefit has not given a lot. If
fortunately, you give them a portion because for holiday, 2006 or years, survey about
my lord.
survey now.
Yes, my lord. But benefit has not given a lordship. Then plus only compensation have given a lot. Only compensation has been given. So far the resettlement as per this scheme of lordship for yes, sir. My lord.
You are right that digital possession in the sense you are
Yes, that
से ज्यादा बाहर करा
করা যায় না। Yes, my lord.
কিন্তু 24 possession মানে নুহে যে ଆପଣଙ୍କୁ ସେ ଜାଗାରୁ ଜବରଦସ୍ତି ବାହାର କରିକି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ତାର ଅଫିସର ମାନେ ଇଏକୁ ରଖିବ ଏବଂ ସେମାନେ ଚାଷବାସ କରିବେ ତାହାର ଏମିତି କୁହାଯିବ ଯେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଆକୁ କରିବେ ତା ମାନେ ସେଇଟା
My lord. That is
ମାନେଟା ଏଇ ଯୋଉ ଆପଣଙ୍କର ଡିସିସନଟା ନିଆଗଲା ସେ ଡିସିସନଟା ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟ ଗଲା ନାହିଁ ଯୋଉଟା ପ୍ରଥମ ଡିସିସନଟା ଯୋଉ ସର୍ଭେ ପରେ ରିସର୍ଭେ ହେଇକି ଆପଣଙ୍କୁ ଯୋଉ ଏକ୍ସକ୍ଲୁଡ କରାଗଲା
my lord.
କେବଳ ବେନିଫିଟ ଦିଆଗଲା ଲେଖା ହେଇକି କାରଣ ସବୁ ଭିଲେଜର ରିପ୍ରେଜେଣ୍ଟେଟିଭ କଲେ ସେମାନେ ଏଗେନ୍ ଆପଣ ସେ ଅର୍ଡରଟାକୁ ମଧ୍ୟ ଚ୍ୟାଲେଞ୍ଜ କର My sister
Yes, sir.
has pointed out.
So you are not agreed by annexure rate. Are you agreed by annexure rate?
Now, lord. Yes, sir.
Agreed by annexure rate.
Yes, sir, lord.
No more challenge. अभी challenge is for active right of people to occupy an order. Just not against. I am not supposed to challenge that. आप prayer देखिए कौन देखने में
Occupant provision से order ये भी भूल लेके जाओ
आपको देखने में अपने दिया नहीं बोला
Yes, sir.
you order का आपको कैसी
Annexure rate, not refer passing of the annexure rate. Yes, sir.
How can we not challenge a particular thing? How can we say that that has gone against you?
Yes, sir. Lord.
In order to come to conclusion, the order of conclusion of what the order of conclusion was clear. It is 68%.
Yes, sir. Lord. In view of the
Few of the proceedings in each instant case are discussed upon. Compensation of delays so was paid to majority of awardees. Possession taken over by this so and as per the claim of the petitioner for applicability of compensation as per new act is unsustainable. In order to uphold the bill
yes.
in order to uphold bill I got support challenge this order in
Yes.
court, sir. Are you coming?
or is it your case that in spite of this order you are entitled for benefits under 2016? That your case? And please look at paragraph 10.
Lord, kindly paragraph 10. Yes, your lordship. The order I have not annexed, but that is mentioned in annex 8, your lordship. The writ application number. My lord. My lord. Yes, sir. My lord. Yes, sir. Lord. I'll check. File the amendment with the Lord. Permitted to withdraw to file better. My lord. Yes, yes, sir. Lord. Yes, sir. I'm filing. My lord, sir. Yes, sir. Yes, yes, I'm doing. Another 5, 6, 7, 12. পাঁচটা আছে 1, 5, 6, 7, 12. 5, 6, 7, 12.
Perhaps the first petition I probably was not there. The first one I was not. First, second one was 3 though, so I thought I want it.
Okay.
He has got a good case under 2006 scheme, 2030. Man. 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 Man.
Item 2.
For to withdraw with a negotiation better
High level.
Item 3.
That matter was before your lordship on 21st 1 2025 your lordship. Lordship has already acted to check to open the platform. So yeah.
Not to have a copy of the reputation, my lord.
Give him a copy. We'll take up this matter on Monday or Tuesday, whatever it is. Why are we not giving when state is party? Why are we not giving the copy to the state council? So let it come on 28th. You serve a copy. Learning Council for the state submits that he has not received the copy of the petition. Let the Learning Council for the petitioner serve a copy of the petition on the Learning Council for the state. Matter will be listed on 28th January 2025. 28 तारीख दिन आसियो. Please tell me.
Item 4.
Sir, my lord, I am a purchaser of a piece of land for the year 2010, 24 to 2010. Was annexed to civil. But subsequently, my lord, an inquiry was conducted on the annexed code. So thereafter, I came to know that that has been cancelled in the year 1996 for leave which has been granted in favor of the vendors. What's the under annexure 1, lordship will find case 12.
You are challenging what?
I am challenging that order passed by the additional district magistrate.
Yes.
Additional district magistrate, your lordship.
Yes.
Under annexure 5. Subsequently,
No, it's a 1996 order.
96 order. It is not known to anybody else. It is not
Known
known
to
to
anybody
anybody else. But your lordship may kindly say annexure 4. I have got that certificate.
No, you please read it out. That 1996 order you challenge in 25.
No, the earlier married the petition has some declaration also, but direction liberty was given to file a better application. The WPC number 25076.
No, you read it. 96 order. You read annexure 5.
This revision on my own motion under section 7A3 of the OGLS Act 1952 arises out of grant of lease by the additional Tahsildar Kottar, it is order dated 5/1/84 in WL lease case number such and such, settling an area 200 decimals out of plot number 115 under Khata number 234 of Kanjim Ama in favor of Janardhan Hathi, son of Chakradhara Hathi of village Kumar Bastra.
So the lease was granted to
Janardhan Hathi.
Just a minute. Janardhan Hathi.
Annexure 1.
Okay. You are not the Janardhan Hathi.
No.
Okay. You are you got any relationship with Janardhan?
Yes, my I have written the annexure 2 series, madam. The sell deeds. Janardhan Hathi sold the land.
Acha. Kebe apanu sell kala?
See, Janardhan Hathi sold the land on 23 1994.
23?
1994.
Just a minute.
1988. To my lord Kuntola Kumari Rautra.
ଆପଣଙ୍କୁ କେବେ ଆସିଲା ଫୋନ?
ମୋତେ ଆସିଲା 2010
2010 लीज कैंसिल ହେଇଗଲା କେବେଠୁ?
लीज कैंसिल ହେଇଛି 96
ତାହେଲେ
2010 ରେ ସେଲବି ଦେଇଛି ଆମେ।
ତାହେଲେ 2010 ରେ ଆପଣ କେମିତି ସେ ଦବ?
ସିଏ
ଆଉ କିଏ ଦବ?
ସେ ତାପରେ ଭେଣ୍ଡର ହେଇକି
ହଁ ଭେଣ୍ଡର ରେ ଯେ କେମିତି ଦବ? ଆପଣ ଯଦି ଲିଜ ଟା एक्स को लीज दिया है गवर्नमेंट से लीज कैंसिल हो गलानी 1996
that has not seen the light because my unless how it will be registered in my name unless and until it will be deleted from the registry
no how the opportunity of hearing would be provided to you say that while passing this order principle of natural justice has not been followed. You are nowhere in the picture in 96.
Yes, you are absolutely correct. But given opportunity of hearing has not been, I will be on the shoe of my vendor.
Yes.
Vendor has not been given opportunity of hearing.
Who says that vendor has not been?
The order itself shows.
Just see that.
My lord.
The second paragraph.
So OP, lessee.
Yes.
OP lessee, your lordship, by that time he is not the owner. My lord, your lordship, kindly
say 1996 कथा कुहाउची
96 रे जनार्दन हाथी नाही पिक्चर रे सी 88 रे सी जनार्दन हाथी बिकलानी कुंताळ कुमारी राउतराय 93 रे कुंताळ कुमारी राउतराय बिकलानी सौदामिनी पटनायक.
इट्स ऑल राइट जहा नारे लीज दिया हैतला से माने ताकू अपॉर्चुनिटी देबे प्लीज कैंसिल कर जदी सब्सिक्वेंट परचेजर से जिंस जदी नोटिस को न आनिबो आपण आपण सेल डीड कर दी चली जिवे that is not brought to the notice of ये तेणु how do you say
मतलब ये रिपोर्ट ता जणा पड़ले तक नोटिस हिंची नै जणा पड़िबो एक्चुअली माय प्लीज मतलब vendor no opportunity has been given.
It is likely the opposite party lessee did not submitted any reply in response to the so-called notice.
Yes. That means he has not appeared.
Yes. So how do you say that principle of natural justice has been flouted?
Because by that time the land was not with Jonathan Hathi. It has been alienated to different persons.
Where is the original lease deed?
Lease matter that is under OGLS Act. It is not deed in fact. It is a settlement.
Yeah.
Under OGLS Act, under Annex 1.
Yes, let us see.
Annex 1.
Yes. What were the terms and conditions of
there
that?
There is no term, only settlement. OGLS Act because he is the you not seen kindly see page 30. There is no lease deed matter granted with terms and conditions. That is the whole difficulty here.
Just a minute.
It is only one settlement.
So, Mahapatra, you had approached this court earlier.
Hello?
You had approached this court earlier. Where is the order? Page?
Only have stated that it is withdrawn. Subject it was allowed to be withdrawn to file a letter.
You quoted the order. You quoted the order.
Only said that was supposed to.
No, we have to see that order. Let us see.
File that. So, Lordship may take it on next week. I will file that order.
And is it your case that the person to whom the land had been sold, he has not come before this court challenging? How can you be so sure?
No, madam, because you Lordship, why I am sure, madam.
Because listen, number of cases, because you are saying this court in other cases has allowed that they should be given a chance of hearing. So many vendors, they come here. If that has already been heard and settled and dismissed by this court, why should we entertain again?
You are not the first vendor. Rightly, it has been pointed out that you are not the first one.
No.
Because it has passed through several hands. Right?
So then, my lord, I will take instruction. I will sign on appeal. You will take it. It is absolutely fine.
Where have you stated that how this went to you?
Yes, sir.
Paragraph
Paragraph 4, page 4 meters.
प्रथमे सिला थिला जनार्दन हाथी
तो कुंतला कुमार राउतराय
तापरे गला कहा
कुंतला कुमारी राउतराय
ओके देन
your lordship कुंतला कुमारी राउतराय sold the land to सौदामिनी पटनायक
तापरे
then thereafter I have purchased from
to अरुणाबाला पटनायक you are अरुणाबाला
सौदामिनी पटनायक but say some portion matter to अरुणाबाला पटनायक some portion 150 decimals she has purchased.
Another
the second vendor Kuntola Kumari Rautray sold the land to two people, Saudamini Patnaik and Arunabhala Patnaik, and the petitioner has purchased from both the vendors, Saudamini Patnaik as well as Arunabhala.
Thank you.
Right. So, as my sister has pointed out, you are to say that this Kuntola, this Saudamini, or this Arunabhala, they have not earlier approached this court.
Yes.
Right?
And I have to supply that
under that earlier order. And you should have also mentioned in the date chart also. Once you have approved this court, and an order has been passed, in the date chart it should have been reflected. That is not there.
That is not what I have mentioned in my para 12.
No, date chart helps us
Yes, sir. I'm sorry.
appreciate your case
That-
faster. So you
I'm
give,
sorry, madam.
give a fresh date chart.
I will amend that date. I'll supply that date.
This writ petition has been filed by the petitioner Govardhan Hathi, challenging swan. So they are portion.
Perfectly, my lord, I have also.
In paragraph number 4, it is stated how the land came to the possession of the petition by way of registered sale deed. The London Council for the petitioner placed the impugned order dated 7/9/1996, which was passed by the Additional District Magistrate Khurda. We put a pertinent question to the London Council for the petitioner as to why there is inordinate delay of so many years. Years of calculated for 2025 minus 20 in challenging the orders, and whether the Bhendi who got the land from Janardhan Hathi, in whose favor the land was passed settled, whether challenge the said order before this court earlier or not. The Land Council for the petitioner seeks time not only to obtain such instruction, but also to produce the order which was passed by this court in the earlier writ petition filed by the petitioner in WPC number 25076 of 2024, which is stated to have been disposed of on 9/10/2024, and also to amend the and also to file a fresh date chart. As the earlier filing of the writ petition is not mentioned in the list of dates and events. Put up this matter.
Next week, Lord,
Let it come in week commencing from 3rd February 2025.
in fourth, my lord, I have some personal difficulty after fourth, Lord.
Then let it come on 6th December,
Yes, Lord.
6th February.
Deep Lord.
Item 8.
May I please, madam?
Yes.
My lord, may I kindly give a glance, page 6, my prayer in the description before my.
Yes.
My prayer relates to denial of interest on the gratuity amount, man. Though the Lord Tribunal had order dated 9/10/2024
That is annexure 7.
my lord has allowed my
Come to your prayer in that before
OA,
that OA. First paragraph mention it. That is page number 22.
my lord.
Please place it.
To pass the order of rejection dated 20th January 2021 under annexure 5, to direct the respondents to conclude the period from 21st 11/1986 to 11/2/1991 as qualifying service for payment of gratuity, and to direct the respondents to pay the differential gratuity with 12% interest for the delayed period, and pass any other order as this tribunal deems fit and proper in the interest of law.
Okay, now what relief you got from the tribunal?
My lord, your lordship, kindly give a glance. Page 27, para number 10 of the tribunal's order.
Yeah.
In view of the above discussion, this tribunal finds that the action of respondents in rejecting the claim of the applicant for counting the period of of her ad hoc service, that is from 21st 11/1986 to 20th February 1991, is illegal and bad in law. Accordingly, the order dated 20th January 2021 is passed, and resultantly, the respondents are directed to compute the period from 21st 11/1986 to 11 February 1991 as qualifying service for payment of gratuity
So
only.
there is no discussion at all on this 12% gratuity.
It amounts to rejected. So my claim is based on rule
What do you
60.
say?
That's the first time it has come.
All right. This writ petition has been filed by the petitioner Sanjukta Patra, challenging the order dated 9/10/2024 passed by the Land Central Administrative Tribunal Cuttack Bench in OA number 428 of 2021 with a further prayer for a direction to the opposite party for payment of 12% interest on the gratuity amount. Stop. The Land Council for the petitioner submitted that the petitioner approached the Land Tribunal inter alia with a prayer for a direction to compute the period from 21/11/1986 to 11/2/1991 as qualifying service for payment to the opposite party to pay differential gratuity with 12% interest for the delayed period. After the counter affidavit was filed by the opposite party and hearing the London Council for both the parties, the London Tribunal has been pleased to hold that the action of the opposite parties in rejecting the claim of the petitioner for counting the period of for ad hoc services, that is 21/11/1986 PO2 10/2 1991 is illegal and bad in law, and accordingly passed the order dated 2021 and directed the opposite party to compute the period from 21/11/1986 to 11/2/1991 as qualifying service for payment of gratuity only. Stop. The London Council for the petitioner submitted that even though specific prayer was made for a direction to the opposite party to pay the differential gratuity with 12% interest for delayed period, but there is no discussion in the order as to why the petitioner would not be entitled to get such interest for the delayed period. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The London Council for the Union of India, Mr. Padi, so and so, and
S.S. Kashyap.
S.S. Kashyap accept notice on behalf of opposite party number 1, then
1 to 4 and I'll short copy on something.
no, why notice should be issued to the joint register? Joint register, deputy register, eman kon pai notice? Opposite party number 1, 3 and 5. No notice shall be issued to opposite party number 2 and 4. Extra copies of the writ petition be served on the Land Council for the Union of India. Matter be listed after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes.
Item 9.
Listener is the displaced person and land LC in the coal bearing area
And as per the R&R of Police Act in 89, the elder son of the prisoner got the employment in the court during area. So far as the other son is concerned, he is a mentally retarded person and
You have submitted your representation.
under Annex 6.
You have not got any response, even though it is September 23.
No, no.
Earlier, he has filed a writ application, direction to the MCL to consider one son has been got benefits.
No, no.
This is the second son.
Where is the earlier order?
That is Annex 4.
4.
Yes.
So, on this particular order of this court, what you have done?
This is the MCL matter. MCL has given one son service benefits. This is the mental retard second son. His
No, we
grievance
are
is
not on that. 2010 ରେ
yes,
ଯୋଉ
representation
order
has
ଟା
been
pass ହେଲା ତାପରେ ଆପଣ କଣ order pass କଲେ?
representation has been considered and one son has been given service benefit. That is his. He has already mentioned in the writ application.
Okay, that is annexure 5.
Yes.
So this issue was not before the authority. এই ଯୋଉଟା ବର୍ତ୍ତମାନ ସେ ଉଠଉଛନ୍ତି ଏ ବିଷୟରେ ସେଥିରେ କିଛି କନସିଡର କରିଛନ୍ତି କି?
Your Lordship,
ଆର ଯୋଉ ମେଣ୍ଟାଲି ରିଟ୍ରାକ୍ଟେଡ
yes,
ସନ୍ ଟା ହେଲା
paragraph number 4. Adibandhu Pradhan, the son of such and such, Pradhan has two major sons, Pintu Pradhan, Lipun. Pintu is of unsound mind, hence unable to render service. The prayer of the person, Uttartha Naik, is to give rehabilitation benefit in shape of job out of land action to his grandson Lipun and package to Pintu as per law, the statement is circumstances, and accordingly.
ପିଣ୍ଟୁ ବିଷୟରେ କଣ କହିଛନ୍ତି ଆପଣଙ୍କର ଅର୍ଡରରେ? ଯୋଉ ଅର୍ଲିୟର ଅର୍ଡର ଟା ପାସ୍ କରେ
MCL order.
ହଁ ସେ MCL ର ଅର୍ଡର ସେ ବିଷୟରେ କିଛି କୁହା ହେଇଛି କି?
Yes, going through the petition, the document statement given by the personal manager, Your Lordship, page 27. It reveals that in all the land record, land acquisition proceeding, the name of the petition, the recorded tenant are Hadibandhu Naik and Uttartha Naik respectively. As per RNR policy, Hadibandhu Naik is entitled for one rehabilitation benefit and his son Lipun, the grandson of Uttartha Naik. The recorded tenant has been sponsored and screened for job as rehabilitation benefit. The claim of Pintu, the second grandson of Uttartha Naik and son of Hadibandhu for a package benefit is not tenable and justified as per policy. The affidavit submitted by Hadibandhu Pradhan, Lipun Pradhan as Pradhan Naik is accepted and is left open for the MCL management to consider Uttartha Naik, Hadibandhu
So
Naik.
they have already decided that
there are two parts. First part is the rehabilitation. As per the rehabilitation, they have appointed one person for employment. Another is for resettlement benefit. There is a notification of the MCL and that as per that notification, they have to extend.
Let us show that.
Well, the notification is not there. Despite my best reports, I could not able to collect. That is the notification of the MCL matter.
All right, so let the representation be disclosed.
And representation that two address and nine. So they
କାହାକୁ ଆପଣ ଆଡ୍ରେସ କରିଛନ୍ତି? ନାଇଁ ନାଇଁ ଏଇଟା
I'll make a press.
ଆପଣ ଏଇଟା କାହାକୁ ପଠେଇଛନ୍ତି?
To the opposite party number 2 and 3.
ସେ ସିରିଜରେ ଦେଖିଲେ ଆପଣ
registered post ରେ ପଠେଇଛନ୍ତି ନା କେମିତି ପଠେଇଛନ୍ତି ନା ଖାଲି ଗୋଟେ prepare କରିଛନ୍ତି reply
ରିସିପ୍ଟ
କରିବା ପାଇଁ
ଅଛି ପେଜ ନମ୍ବର 30
then ନାଟା ଥିବ
କାହାକୁ ପଠେଇଛନ୍ତି ଦେଖିଲେ ତ ଜଣା
The
ପଡୁଛି।
general manager MCL.
ନାଇଁ ଗୋଟେ ଯାହା ଯିଏ ରେଲେଭେଣ୍ଟ ପାର୍ଟି କୁହନ୍ତୁ ଆମେ ଯୋଉଥିରୁ ଜଣା ପଡୁଥିବ ଆମେ କହିବୁ ଯେ ସେଟା ଦିଆ ହେଇଛି ବୋଲି। ତିନିଟା ବର୍ତ୍ତମାନ ରିସିପ୍ଟ ଅଛି।
Yes, general manager, area personal manager, and
the person who should consider ये से order टा pass करते हैं तो चाहिए बता consider करिए।
According to you, who can consider it? ଏଇ ଯୋଉ ଆପଣ ଯୋଉ ଚାରି ଜଣକୁ ଅପୋଜିଟ ପାର୍ଟି କରିଛନ୍ତି କିଏ କନସିଡର କରିପାରିବ ଏ ବିଷୟରେ ଆପଣଙ୍କ ରିପ୍ରେଜେଣ୍ଟେସନ ଏବଂ ସେ
clear order was passed by the land acquisition officer MCL on.
It's probably MCL.
OP number 2.
OP number 2 जनरल मैनेजर
Yes.
जनरल मैनेजर को ଦେଇଛନ୍ତି ରିପ୍ରେଜେଣ୍ଟେସନ
Yes.
କେବେ କାଇଁ କୋଉଠି ଦେଖିଲେ କୋଉଟା
The registration receipt.
ରେଜିଷ୍ଟ୍ରେସନ ରିସିପ୍ଟ କୋଉଟା जनरଲ मैनेजर
First GM MCL.
18-23.
Right, take down. This petition has been filed by the petitioner Hadibandhu Pradhan or a direction to the opposite parties, more particularly to the opposite party number two, to extend the SPO R&R benefit, that is financial package, to the mentally disabled son of the petitioner, namely Pintu Pradhan, as par with other land losers in reference to the policy decision of the government. The Land Council for the petitioner submitted that highlighting the grievances, the petitioner has submitted a representation on 8/9/2023 before the opposite party number two on and which should be evident from the receipt annexed to the annexure number 6 postal receipt, but he has not received any communication from the opposite party number and praise for direction to the opposite party number 3 to dispose of the representation within a specified time and to communicate the decision taken on such representation. Land Council for the so and so has no objection to such prayer without expressing any opinion on the merits of the representation under annexure 6, but is obligated 3 months from the date of production of the certified copy, but 2 weeks from the date of taking decision, it will be communicated. Yes, disposal.
I am for only OP number 1.
The Land Council for the OP number 1. Now, Mr. Deputy Solicitor General plus Mr. Gupta. Yes.
Item 10.
Madam, Karvek is there and she is serving the copy of the
in view of the just a minute, in view of the formal nature of prayer, we not think it proper. We should notice to the opposite party number or passing this order for disposing of this limited nature of the part. Yes, item number. Yeah.
Serving the copy of the restitution plus development is also there. That also has been call it 7 days.
So you are appearing for whom, Mr.
I am appearing for the respondent institute. Since I don't have the copy, because I don't know who
is it National Institute of Fashion? Okay, there are that means 2, 3 and 4.
Yes.
You would appear.
Yes. Sir, they have to copy it and
no, 2, 3 and 4. So देखिए दो ना तुम copy दे just give it.
Yes, there is a OP number 1 is Union of India, other are NIFT.
No, one you will appear, Mr. Pari, but 2, 3 and 4.
That I have given up.
No, that is.
I don't know this, what they have done. Actually, I don't have any instruction
Union of India.
to whom they are engaged on behalf of Government of India. It is known to
The
copies are cordially.
Land Council for the so submits that he has instruction to appear for opposite parties number 3 and 4, and he will file your wakalat nama.
Caveat, I am on caveat.
Caveat is already filed, and copy of the petition is served in court. The Land Council for the petitioner has also served the copy of the petition on the Union of India. Hello, Mr. Pari. So, what do you want? You want to obtain instruction in the
yes, 7 days.
This petition has been filed by the petitioner, S.K.Sahoo, challenging the order dated 10/12/2024 passed by the
11/12.
prayer 10/12.
Termination order is 11/12. CAT order is 10/12.
Yes.
So after the cat order, you were terminated.
Terminated. That is under
All right.
that means I am to bring a
10/12/2024 passed by the Learned Central Administrative Tribunal in OA number 236 of 2021. Right. दोस्तों 10 तारीख से ये जो 10/12/2024 बाकी तापरे ये ऑर्डर कौन पास करा आपने
Rather terminate कर दीजिए. Regulation was filed and that was dismissed. Thereafter, on the day it is dismissed, it termination.
You have not challenged Annexure 8.
That I have impugned before the tribunal. This is the consequence. They have dismissed. That I have challenged before the tribunal. That I will bring to the notice of your lordship.
So that is pending.
It is pending. It is listed today. It is also listed there.
All right.
Stay is there.
Stay is there.
Stay is also there.
Termination stays there. Okay.
Is this matter after 2 weeks for them? Issue notice on the question of so and so for the accept
Instruction it
is submitted by the Land Council for the petitioner. That
you are there in that petition. You have appeared. So by the
after
parties.
passing of the impugned order dated 10/12/2024, the petitioner has been terminated from the service by Annexure 8 on 11/12/2024, and the said order is under challenge before the London Central Administrative Tribunal.
Number?
OA number 769 of 2020.
In OA number 769 of 2024. An interim order has been passed in the said case. The copy of the order is produced, which is taken on record. The Land Council for the opposite parties number 2 to 4 6 times to obtain instruction in the matter. Then let it come when it has been fixed to.
First. Third or fourth
Petitioner भी बोलते हैं
to obtain instruction and matter will be listed after, let us say, 2 weeks after. Read this matter.
Your lordship is assigning any date.
This is
2 weeks.
you can get it on let us say on 17th, let it on 17th February 2025.
Obliged.
Seal for the yes.
Item 11.
The petitioner is the owner of the land, and the government is constructing the approaching road to the bridge. No acquisition was made and no compensation was made.
In this case, what happened, my lord? The land originally belonged to Atgad Raja. One Golak Bihari Rai, he by way Sebat Samarpana Pata recorded the land in his own name.
No, his grievance is now Annexure 9 is pending. That is the representation he has given
For the
collector. That is not yet been disposed of.
Yes.
So you assign whatever reason and dispose of Annexure 9. Right? Annexure 9 is the presentation that is dated 8th of November 2020. And it is addressed to Collector Cutter is the opposite party number 2. Hello? What's the usual order? Dispose of period. Yes.
Item 13.
But while hearing a lot opportunity may be given, but
If necessary, opportunity. Yes. May I please, Your Lordship? Here the land of the ancestor of the petitioner have been acquired for the Rengali Dam project Mela, and they have been awarded compensation. In the meantime, some of the land houses they have objected to the award amount, and the reference was made to the city judge senior division Devgarh, where the compensation amount has been increased. Accordingly, the ancestor of the petitioner filed a petition under section 28A of the Land Acquisition Act 1894. That is annexed to Mela total order sheet, where they have increased the compensation Mela. And it has been referred to the state government under Annex 4 in the year 2023. But same is not yet been paid, man. That is the only my grievance. Which reference to come to Annex 4.
Yes,
And to submit the tentative calculation sheet amounting to so and so along with so and so filed by sanction and decretal dues of the gratuity. So you take instruction in this matter. This has already been done. Calculation sheet has been
you'll also make a
submitted.
direct to comment to dispose of.
No, there is no dispose of. It is pending for sanction
Yes,
of the decretal amount. And that in 2023.
Yes, yes.
2 years is going to be elapsed in the meantime. So you should sanction it. There is no, if you don't challenge it, this is the decretal amount, so it is to be sanctioned.
There is no other legal.
If there is no illegal impediment, if you challenge, it's all right. If it's not, then you have to sanction it. You take instruction on that. This writ petition has been filed by the petitioner Dharanidhara Nanda with a prayer for a direction to the opposite party for payment of the awarded amount as awarded under section 28A of the Land Acquisition Act. The Land Council for the petitioner submits that the Zone Officer Rengali Dam Project Deogar bracketary opposite party number 3 has submitted the calculation sheet in 28A case filed by the Tonkadhar Nandaki, father of the present petitioner, by the father of the petitioner and others. To the director, bracket R&R from Additional Secretary to Government, Department of Water Resources, Orissa, Bhubaneswar. Secretary question. And question number 1 is the secretary matter. Water Resources.
You are the only legal heir of Pankaj Nanda.
Other 3 years there.
Where have you mentioned?
That annexed to it is mentioned by that. Step 2, another amounting the tentative calculation sheet amounting to rupees 2,82,644 along with the relevant documents in connection with the said 28A case. For sanction of the decretal amount under Rengali Dam project. But till date, no sanction has been made. Let the Land Council for the state obtain instruction as to why the sanction has not yet been, some sanction of the decretal dues has not yet been made, and whether there is any legal impediment for such sanction or not. Of this matter in the commencing from 10th February 2025. 14th also same matter. Amount भी अलगा थी बोलते अलगा थी इटे 11 लक्ष थी amount टा खाली डिफर करियो एटा सेही टाइप रो रखे है ना
Mr. Guru, the father is Chintamani Nanda or Tankadhar?
in the first case
13 says Chintamani.
no in the first case Tankadhar Nanda it is out the petition আছে ওদের নম্বরটা হচ্ছে
3325 order sheet says Chintamani Nanda and then late Chintamani Nanda order sheet which you referred to.
But in my petition, I have written Dharanidhara Nanda son of late Tankadhar Nanda.
You have written, you also mentioned that Tankadhar Nanda had filed,
Yes.
and the letter annexure 4 is also says Tankadhar Nanda.
Tankadhar Nanda
So
son
is it your case that Chintamani died, then Tankadhar died, and then you are on record?
on record. That is in the next 2, my lord.
Annexure 2 re to asuni na, that is why I asked. 28/6/2014, where is the
27
application of Chintamani Nanda?
that page 11, my lord.
Yes,
Order dated 27/11,
yes,
2014.
yes.
The put up today that the notice has been served and the SR is back on call legal as three son of that Chintamani Nanda are present.
ସେଥିପାଇଁ ଆମର narration ଟା ଭୁଲ ହେଇଯିବ, that is why I am asking.
Chintamani Nanda is one of the.
So ସେଟା ନ କଲେ order ଟା ଭୁଲ ହେଇଯିବ.
Sorry, my lord. Chintamani Nanda also a wadi along with the Tankadhar Nanda.
ଇଏ କଣ ତାହେଲେ କଣ? ଟଙ୍କଧର ନନ୍ଦ ମରଲା ଅଛି ବୋଲି କୁଆଡୁ ଆସିଲା ଆମର facts ଟା କୁହାହେଲା ସେଟା ଭୁଲ ଭାଲ ହେଇଯିବ. Because we are stating the background. ଭୁଲ ହେଇଯିବ ନା.
Paragraph 3 I have written, my lord. Chintamani Nanda and his brother Tankadhar Nanda both are son of late Satyavadi. Paragraph 3 of the petition I have mentioned.
So both died. Have you
Both
stated? Where have you stated?
Paragraph 3, my lord.
Because we are stating the facts, we have to state it correctly.
Paragraph 3 of my petition I have stated. In the 3325.
କୋଉଠି ମରିଗଲା ଟଙ୍କଧର ଟିକେ?
Tankadhar ମୁଁ ଇଏ ଦେଇଛି ତାଙ୍କର ଡେଥ୍
ଆରେ
ସାର୍ଟିଫିକେଟ।
ମରିଗଲା ବୋଲି କୋଉଠି ଲେଖିଲେ? We have to state that ନା, ଆମେ କଣ ଗୋଟେ କହିଛୁ ଭୁଲ ଭାଲ କରିକି.
ସେ ଯୋଉ ଇଏ ଦେବେ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଦେବେ
Paragraph 5 ରେ ଲେଖିଛି।
paragraph 3 ରେ ଲେଖିଦେବେ ଟିକେ. The Land and Council for the petitioner submitted that Chintamani Nanda and his brother Tankadhar Nanda.
Paragraph 5 ରେ ଲେଖିଲେ ଟଙ୍କଧର ପ୍ରଧାନ.
Death certificate I have annexed Tankadhar Nanda.
Where the recorded tenants in respect of Khata number 12 for areas also, which were acquired for the purpose of Rengali Dam project. And the award was passed in favor of the land users. The land users being aggrieved with the award amount approached the Civil Judge Senior Division Devgarh for enhancement of the compensation amount, and accordingly, LA case number 19 of 1997 was registered and filed judgment dated 7/8/1999. The Land Civil Judge Senior Division Devgarh enhanced the compensation amount. It was upheld by this court. Case number which they know, the election is upheld by this court.
FA or ନା କଣ? FA.
LA ହେଇଛି Land Acquisition Appeal.
Recently, ଯଦି ଆଗରୁ ହେଇଥିବ FA ହେଇଥିବ.
After the judgment was pronounced by this court, the ancestors of the present petitioner filed an application under Section 28A of the Land Acquisition Act for enhancement of the award amount on 26/2014, and during its pendency, the original ROR holder Tankadhar Pradhan passed away. Tankadhar Nanda passed away on 10/7/2018, and the petitioner Tankadhar Pradhan ଆପଣ କହିଲେ ପରା ଆପଣ ଛଡା ଆଉ ଆପଣଙ୍କର ଭାଇ ମାନେ ବି ଅଛନ୍ତି।
ସେଟା ଆର ରିପିଟିସନ ସେକେଣ୍ଡ ରିପିଟିସନ।
Second
petitioner
Chintamani Nanda.
substituted himself as the legal heir.
ସେ ସବୁଆଡେ ଟଙ୍କା ନନ୍ଦ ହଉ ସେ
ହଁ।
ଭୁଲରେ ଗୋଟେ ଗୋଟେ ଜାଗାରେ ପ୍ରଧାନ ଦେଇଛନ୍ତି ସେ।
And then, after hearing the parties, the land acquisition officer, Deogan, passed the order to enhance the awarded amount, passed the order on on 31/3/2023, in enhancing the awarded amount. Hello? And accordingly, the zonal officer, Rengari Dam Project, Deogan, awarded a sum of rupees 2,82,644 as the award amount under section 28A of the land acquisition. है ना? तापरे सेटा लिखिले से जो देला sanction करिया ପାଇଁ जो तापरे instruction ତାର background ଟା ରହିବ. Okay, next.
ସେମ୍ ହବ
Voting is the legal heir of Chintamani.
ଏଟା ଟିକେ ଅଲଗା ହବ ସେଟା ଦେଖିନି ସେମିତି ଲେଖି.
ମାନେ ଆପଣ ଡେଟ୍ ଚାର୍ଟରେ ଯଦି କେସ୍ ନମ୍ବର ଫମ୍ବର ଦେଇ ଦେଇଥାନ୍ତେ ଭାରି ସୁବିଧା ହେଇଥାନ୍ତା।
ବାହାର କରିଦେବି.
ଖୋଜିକି ଭୁଲ ହେଇଯିବ।
Next.
Item 15.
15.
Item 15, a copy may be served. The railway is there. East Coast Railway and Southeastern Railway both are there. But we didn't receive the copy.
Union of India ଅଛନ୍ତି ତା ଛଡା East
East Coast Railway and Southeastern Railway both are there.
Right.
petitioner ନାହାନ୍ତି।
You are for the petitioner?
No, I am from the.
He is newly joined with me as a council GC in the.
Only we are getting confused କା ପାଇଁ ଅଛନ୍ତି ବୋଲି।
So with the council, Deepak Ranjan Sundar Roy. The council is not there, we are passing it over, no?
Oblige, my lord, yes.
Item 16.
Yeah.
My limited there is not that approach before the opposition of two chocolates or ballots dispose of his lease appeal, which was in filed lease appeal number 235/2023. So it was filed in the 2023, but it has not disposed of. I have filed the order sheet of page 21. In that order sheet, it has shown that the PO is busy, so it has been adjourned so many times. So in the meantime, the land in question which was allocated to the opposite partner 6 is now going to constructor over the plot. That land was initially allocated on Abadi and it was used by the local Hatto. Thereafter, it has wrongly decided in the name of opposite partner 6. In page
ଆପଣଙ୍କର ସବ୍ କଲେକ୍ଟର 2023 ମସିହାରୁ ପୁରା ବିଜି ରହୁଛନ୍ତି, ଜମା ତାଙ୍କୁ ସମୟ ମିଳୁନି, ଆଉ ଏଗୁଡା କାହିଁ ଫାଇଲ ହଉଛି ତାହେଲେ ତାଙ୍କ ପାଖରେ?
This was never before this court.
No.
And
another thing is also filed petition on court.
Sorry?
Another in the similar dispute, another 3 petition also pending.
କୋଉଠି ତାର
Number ଗୁଡା କଣ?
Number lordship WBC 920 of 25, WBC 932 of 25.
ଗୋଟେ କାଗଜରେ
Yes, ma'am.
Please this matter along with WPC number. Toda କିଛି order ହେଇନି?
No, that is separate case matter. Separate lease appeal which is pending.
ଏଇଟା ଯେମିତି ଗୋଟେ ସେଟା
separate. Yes.
Separate na relates to this only.
Related to this dispute, but in the name of land is recorded in the.
ଏକା ସାଙ୍ଗରେ ଆସୁ ସୋମବାର ଦିନ.
ସୁବିଧା ହବ ନା?
Yes.
Better that you just give the number.
Yes, ma'am.
This matter along with WPC number so and so Tuesday record them 28 तारीख दिन आसी.
Item 17.
Number 17, lordship. Though my representation is pending before the authority, but in respect of this other person, the authority has already rejected my claim, your lordship. Matter is before the honorable court. This honorable court already the matter connected matter to 27/3/2020.
No, let a decision be taken in your case.
They have already rejected the claim. It's a matter, your lordship, that we are the land out still.
Where is that order?
Lordship, they have not rejected my claim. That order.
But you are saying you have already rejected?
No.
In another, somebody else had filed. That's why that's better one and they say. And put a dispose for out the dispose of
Land counsel for the petitioner submits that similar matters are sub judice before this court in WPC number order ଦେଇଥିବ
WPC number 31252 of 2024
ଗୋଟେ
ସେଥିରେ ଗୋଟେ ମ୍ୟାଟର ଅଛି ଆଉ ଗୋଟେ ଆଜି 3 ନମ୍ବର ଆଇଟମ ଥିଲା ସେଟା କପି ପାଇଁ ରହିଲା ଆଜିର 3 ନମ୍ବର ଆଇଟମ
କେତେ ଥର
अच्छा कॉपी दिया है
କପି ଅଲରେଡି ଦେଖିବ ଅଛି
यस यस
ସ୍କାନ କପିର ଯେହେତୁ ଡାଇରେକ୍ସନ ଦେଇନଥିଲି
ସେଟା ଯୋଉ ଆଗ ମ୍ୟାଟରଟା କେବେ ଅଛି
ଆଗ ମ୍ୟାଟରଟା 31,252 ବାଇ
मेरे
24
केबे को अच्छे रे
ଅତି 27/3/25 ଡେଟ୍ ଅଛି
ଯୋଉ ଡେଟ୍ ଦେଇଛି ସେଇ ଡେଟ୍
31,000 तो नहीं 32,000
31,252 of 2024
एकदम 3
21/1/25 ରେ ଡିସ୍କସନ ଅର୍ଡର
डिस्पोजल नहीं जोटा अर्जन है
ଅଦର ମ୍ୟାଟର ଯୋଉ ଆଗର ତିନିଟା ଆଉ ଏଇ ଯୋଉ ଏତିକି ଡିଫରେଣ୍ଟ ମ୍ୟାଟର
ଆମ କନେକ୍ଟେଡ ମ୍ୟାଟର 21,252 ବାଇ 24
ଆଜି ଯୋଉ ତିନି ଥିଲା
ଆଜି 3ଟା ବି ତା ସାଙ୍ଗେ ସମାନ 21,000
ନମ୍ବର କେତେ
ओहो जोटा डॉक्टर होची सेटा कहले हमें एका संगे लिस्ट कर दियंते
वर्षिप 31,252 बाई 2024
Place this matter along with one so on କେବେ ଅଛି ସେଟା
27/3/2025 along with WPC number 28,839 of 2024
ଏଠି କଦିର ଅର୍ଡର ପାସ୍ ହେଇଛି ସେ ତମର ଏଟା ଚାରିଟା ଲେଖା ଆସିବ and in the meantime the land council for the state shall obtain instruction about the status of representation under annexure 8 hala free copy of the order be handed over to the land council for the state filed by the petitioner before the swan so annexure 8 of file the collector Sundargarh is the opposite party number 3
Item 18.
obligatory no the really limited the petitioners are on displaced person and they are under the Kanpur Greater Irrigation Project. They have been affected and they have not been included in the displaced project displaced family. So they have filed their representation several times and in last time in October they have filed by registrar. It is maybe considered that order may be passed by registrar.
135 petitioners you had never approached this court earlier
For the first time,
extra जो कोर्ट फी हरिया सब दे दीछन
again.
अच्छा ये जोटा आपण କରିଛନ୍ତି ତାদের ସମସ୍ତଙ୍କର ଇଏ ମଧ୍ୟ ରହିଛି
you received copy Mr. Maharti
I received their
your representation of
135 petitioners. So
one it is the
group of
135
submission only 5 to 10.
हां
They received ଦେଇଛନ୍ତି
ସେ ଯୋଉ ଦେଇଛନ୍ତି 20 ରୁ 36 maximum 16 ଟା ହବ 16 ହବ ଆଉ ବାକିଙ୍କର କଣ ହେଲା
File some of them are filed.
କେମିତି ହବ ସେ କନସିଡର କରିବେ ଆପଣଙ୍କର ରେକର୍ଡ ରୁ ସେ କୋଉଠୁ ପାଇବେ ନା
ରିପ୍ରେଜେଣ୍ଟେସନ ଅଛି କି ନାହିଁ
Achi, we have.
ଆରେ ଅଛି ବୋଲେ ଆପଣ ରଖିଲେ କଣ ହବ କୋର୍ଟ ସାମ୍ନାକୁ ଆଣିବେନି କପି ଦେବେନି ଆମର ପାଖରେ କିଛି ପ୍ରୁଫ ନାହିଁ
Some of the young filed.
No, କାଇଁ ଆମେ ପଚାରୁଛୁ ବିକଜ ତାଙ୍କୁ ଡିସ୍ପୋଜ କରିବା ପାଇଁ ଅସୁବିଧା ହବ ଯଦି ଆପଣ ରିପ୍ରେଜେଣ୍ଟେସନ ନାହିଁ
ଆଜ୍ଞା ଡାଇରେକ୍ସନ ଦେଇଦେବୁ 135 ଜଣଙ୍କର ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜ ଅଫ୍ ହବ ବୋଲି ତାଙ୍କ ପାଖରେ ମନେକର ଏଇ 16 ଜଣଙ୍କର ଥିବ ଆଉ ଅନ୍ୟ ମାନଙ୍କର ନଥିବ ତ ସେମାନେ କଣ ଆମ ପାଖରେ ତ ପ୍ରମାଣ ନାହିଁ ତାଙ୍କ ପାଖରେ ବି ନାହିଁ
My lord, I'll file it. To just file.
either file ନହେଲେ confined to 16
ଯଦି ଆଇଦର ଫାଇଲ କରନ୍ତୁ ନହେଲେ
No, file. We have.
ମାନଙ୍କ ପାଇଁ ଇଏ କରିଛନ୍ତି ରିପିଟିସନ ଆମେ ସେଇମାନଙ୍କ ପାଇଁ କେବଳ କନଫାଇନ
I have got the.
ଫାଇଲ କରନ୍ତୁ
ଲିଷ୍ଟ କରିକି ସେ ରିପ୍ରେଜେଣ୍ଟେସନ ରେ କାହା କାହା ନାଁ ଅଛି କୋଉ କୋଉ
ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଦେବେ ଏବଂ ତାଙ୍କ ପାଖକୁ ଯାଇଥିଲା ସେ ଯେମିତି
ପ୍ରମାଣ
ପୋଷ୍ଟାଲ ରିସିପ୍ଟ ଟା ଯୋଉ ଦେଇଛନ୍ତି ସେଇଟା ମଧ୍ୟ ଦେବେ ହେଲା।
Page 20 make a glance. ସେ କହୁଛନ୍ତି ବହୁବାର ସମସ୍ତ ଦସ୍ତାବିଜ that is not disclosed. That is
ନାଇଁ ସେ ଆଟଲିଷ୍ଟ ଏଇଟା ଦିଅନ୍ତୁ ସେ
ସେଇ ଦନେ ଏଥିରେ ରିପ୍ରେଜେଣ୍ଟେସନ କେମିତି ଦେଖାଇଛି କଣ କେମିତି
this writ petition has been filed by 135 petitioners for a prayer for a direction to the opposite parties to consider the grievance of the petitioner under Annexure 1 series and for taking of appropriate and necessary steps to include their names in the displaced persons list under Project Displaced Family for giving rehabilitation benefits to them under the provisions of so 2013 Acts and guideline fixed for Kanpur irrigation project. So far as Annexure 1 series is concerned, we find that there are only 16 representations along with the postal receipt to show that it was submitted to the concerned authority. Stop. We put a pertinent question to the Learning Council for the petitioner as to what happened to the representation of the remaining petitioner and whether there is any documentary proof that they have also submitted representation to the concerned authority and whether postal receipt in token of such filing of representation are available. The answer was in affirmative and the Learning Council submits that he will file those representation with the postal receipt and give copy of the same the Learning Council for the state. Kebe rakhiu phone. Put up this matter do we commencing from 3rd of February 2025. Yes.
17ଟା ଅଛି 17
17ଟା ଅଛି 16 ଜାଗାରେ 17 କରିବେ।
କୋଠି ଦେଇ ଦେଇଛନ୍ତି
କୋଠି ଦେଇଛି ଲକ୍ଷ୍ମଣ ଭାଇ। Yes, we are coming.
Item 19.
My lord. Annexure 3 is pending before the OP5, my lords. Project Director, LSAP Bolangi. The affected family compensation not be released in favor of the husband of the petition. And given a representation annexure 3 series, my lord.
Annexure 3 series. 3 series में कौन ये सब अलग ना कौन मैं सही गोटे लोग
मैंने one question.
अच्छा कहाँ को देखेंगे अपन
Project Director L.
लैटेस्ट टा को कौन
मेरे page 37.
37 टा केबे करा
6/11/24.
ହେଲା ତା ଦେହରେ ଷ୍ଟାମ୍ପ ନାହିଁ ସୋ ଦିଟାକ ଲେଖିଦବା
अच्छा और annexure 3 series कर दियो तो it is
ଡେଟ୍ ଗୁଡା ଦେଇ
date दे देबे और फिर project director means opposite party number 5 production of the certificate you must have onboarding this
Item 20.
Honorable Court regulate consequential order of the collector, my lord. Number 2. The land is already acquired and used for the project. Page 47. 13/11/2023 collector had a letter to the OP number 6 executive engineer regarding compliance and compensation compensation of punished action report within a week positively. But
your last representation is annexure 11.
you had come to this court earlier
हाँ मतलब इथरे लिबर्टी दिया गला contempt रे
ସେଟା କହିବେନି contempt ନାହିଁ you have mentioned WBC କଣ ହେଲା ତା ଦେହରେ third round of litigation
तो
third round ତାମାନେ ଦିଟା ରିଟ୍ ପିଟିସନ
ଆଜ୍ଞା ଖାଲି compensation ମାନେ
ଆପଣ ତ ଗୋଟେ ଲେଖିଛନ୍ତି ଗୋଟେ ରିଟ୍ ପିଟିସନ ରେ ଗୋଟେ ଲେଖିବେ ଆରଟାରେ ଆର ଗୋଟେ ଲେଖିବେ kindly see page 43
Page
43
33
43
43
collector has already taken a decision to purchase the land on outright purchase basis only that land amount has to be paid
these assets but subsequently thereafter page 47 is issued by the collector. Part is executed, my lord. OP number 6 executive engineer Dual Works Division 2
work executed
work is executed. Compensation amount assessed but not paid.
work executed ଆପଣଙ୍କ
just come to your last representation
my lord
and page number 53 paragraph number 6 जोटा कि internal page number 3 page number 53 paragraph number 6 टा पढ़िले due to not action by the land acquisition collector I had approached against I approached against the against asset
ନା ନା ହସୁଛନ୍ତି କଣ ଇଏ ଗୋଟେ
ହଉ ହେଲା ପଢନ୍ତୁ ପଢନ୍ତୁ
Honorable Court has passed the
arrear passes arrear arrear
କଣ ଗୋଟେ ଲେଖିଛି
ଯାହା ଗୋଟେ ଲେଖିକି ଗୋଟେ ଦେଇଦେଲେ ହେଲା
direction to the swans dispose of the representation ପଢିଯାନ
with the direction to the elect collector to dispose of representation regarding assessment of compensation within a period of 3 months. ତାପରେ ଏଇଟା consider କଲେ so annexure thereafter annexure 9 page 43 was passed regarding the direct purchase system. Page 43 ପରେ page 47 was assessed 43 assessed ହେଇଥିଲା ଏବଂ page 47 my lord the collector sent a letter to the executive engineer distribution of compensation and punished the action taken report within a week positively page 47 second paragraph but in spite of the very clear cut instructions of the collector through the ADM compensation amount is not paid to the petitioner.
So you mean to say that in spite of this later correspondence which has been made by ADM to the executive engineer that to take immediate action as per the so passed for distribution of compensation and furnish a report within a week
within a week
সেটি কিছু order passing so then you obtain an instruction on that matter କାହିଁକିନା ପୁଣି ସେ representation ଯିବ ଇଏ ଯିବ ଏସବୁ
Thank you.
ଲେଖନ୍ତୁ this writ petition has been filed so chances ହେଲା during course of argument the learned counsel for the petitioner referred to the later it was page number 47 ଅଛି later dated 13/11/2023 issued by the additional district magistrate revenue Balasore opposite party number so and so to the executive engineer RW division number 2 Balasore party karchandi
open numbers 5
opposite party number so and so wherein it is mentioned to take immediate action
खाली अप्रूव है एस्टिमेट टा
अच्छा
ये पेज 43 तो
47
अच्छा sorry
47 to take necessary action as per the order of this court for distribution of compensation and to furnish action taken report within a week. The learned counsel submits that in spite of such communication being made to so and so an executive engineer, no further step has been taken for which the petitioner has not yet received the compensation amount. Let the learned counsel for the state obtain instruction as to whether any order has been passed by the executive engineer R&W division number 2 Baleshwar pursuant to the communication made as per the later dated so and so of the DM revenue Baleshwar. What is this matter? 10 तारिखରେ ରଖିଲେ ହବ କଣ order pass କଲେଣି କି ନାହିଁ ଠିକ ତ
10th
ହେଲା 10th of February 2025.
Item 21.
This is land of the petitioner with house acquired by the opposite party number NX National Highway. And the land has been assessed valuation made, but the so far the house is concerned, valuation has not been made. That's why he has filed a representation under Annex 2 before the Tahsildar land acquisition officer NHL. And according to on 5/12/2022, madam.
Yes.
Basing upon that representation, they have called a meeting under Annex 3. There are some 4 lines I am detailed. ଆପଣଙ୍କ ଆଦେଶ ମୁତାବକ ଅଦ୍ୟତା 17/12/2022 ଶନିବାର ଦିନ ତହସିଲଦାର ସାହାପଡ଼ା ପୋଲିସ ଅଧିକାରୀ ପାଟଣା ଧାନବେଣୀ ଗ୍ରାମବାସୀ ବୃନ୍ଦ ନିର୍ବାହୀ ଯନ୍ତ୍ରୀ ଦ୍ୱିତୀୟ ଜାତୀୟ ରାଜପଥ ରାଜସ୍ୱ ପରିଦର୍ଶକ ଏବଂ ରାଜସ୍ୱ ନିରୀକ୍ଷକଙ୍କ ଉପସ୍ଥିତିରେ ଧାନବେଣୀ ଗ୍ରାମବାସୀଙ୍କ ଉପସ୍ଥିତିରେ ଚିହ୍ନଟ କାର୍ଯ୍ୟ କରାଗଲା ଏଥିରେ ଯାହାର ଯାହା ଅଭିଯୋଗ ଥିଲା ତାହା ସମାଧାନ ପାଇଁ ସ୍ଥିର ହୋଇଥିଲା but they have not considered the grievance of the petitioner and issued a letter notice under Annex 5 page 18 on 3/12/24 just 1 month before to vacate the land but they have not evaluated the house of the petitioner which has been acquired and situated over the land acquired by the NHL.
लैंड टा केबे माने घरटा केबे तयारी करले आफ्टर एक्विजिशन ना बिफोर
2019 I have submitted a report of the junior engineer under Annex 6 page 19 madam. He has valued the house.
Year of construction
My God, 2019. There are 2 houses. A house is belongs to the petitioner and B house is belongs to his father Gautam Mahanta.
So far as the land is concerned, you have received compensation.
Minor.
Where have you stated?
प्रेयर में मांगिले बहुत
ଆପଣଙ୍କର to give ଆପଣଙ୍କର ଯୋଉ actual compensation with proper valuation of the said land and house to the petitioner. ଆପଣ ପରା ନିଜେ କହୁଛନ୍ତି ଯେ ଜମିର compensation ପାଇ ସାରିଲେଣି ବୋଲି ପୁଣି କାହିଁ ଲେଖିଲେ prayer?
With protest. With protest. And the
ଆପଣ କହିଲେ ଯେ ଯୋଉ ଘର ତା ଭିତରେ ଅଛି ତାର ମତେ ଦେଇନାହାନ୍ତି ଜମିର already ମୁଁ compensation receive କରିସାରିଲିଣି ପୁଣି prayer ରେ କଣ ପାଇଁ ଲେଖିଲେ ଜମିର ବି ଦିଅନ୍ତୁ ଘରର ବି ଦିଅନ୍ତୁ ନା ଗୋଟେ ମାଗିଦେଲେ ଯାହା ମିଳିବ
ଯୋଉଟା ରିସିଭ୍ କରିଛି with protest କରିଛି
ନାଇଁ protest receive କରିଛନ୍ତି ଯେ is it a case ଯେ ଗୋଟେ ଜାଗା ଗୋଟେ ଘର is not located on that land? You are saying proper measurement ହେଇନି ଗୋଟେ ଘର ନିଆ ହେଇନି into account.
that is the my grievance.
show us this abandonment taking where have you stated that for the land you have already received compensation good lecture and for the building which situates in that land you have not received ei dita abandonment dekhan
Para 4.
on lecture
That after receiving the notice in the above LA case, the petitioner meets the opposite party number 3, CLA comes officer and receive the award money with protest. After receiving the award money with protest,
the award money ta houtandi kon mane land pai acha apun ko kohun acha ha ठीक है कोड बिल्डिंग पाई आपण फाइनांस बिल कोड लिखा है
just after receiving the award money with protest, the petition came to know that the valuation of his acquired property was very low and valuation of his house was not done.
Okay.
And for which the petitioner had requested the collector reassess the valuation of the acquired property by submitting a recommendation before the collector on dated 5/12/2022.
Then what happened?
Then they have called a meeting on 17/12/2022, madam.
Yes, then
they have in that meeting they have decided that they will consider the grievance of the villagers and the present petitioner also. But till yet they have not considered this and now they are issue notice to.
Then you submitted a petition on 27/3/2023 before the special land acquisition office.
All you are to have a glance.
If ଲେଖା ହେଲା for receiving compensation amount, compensation पर आगुरु receive कलेनी under protest पुणी आउथरे receiving आपनकर annexure 4
on 27/3/2023 I have filed a representation before the authority and he has passed order of at page 13 minor the land acquisition officer तहसीलदार Tapada 23 I have
filed 27/3/2023 रे जो स्पेशल लैंड एक्विजिशन ऑफिसर को गोटे पिटिशन देले तापर कोन हला
से दिन के ऑर्डर पास करले at page 13 of the writ application. Land acquisition officer से 27/23 रे गोटे ऑर्डर पास करले जोटे सर्टिफाइड कर मु फाइल करछि at page 13 minor of the writ petition
13
page 13
से आगे रहले एटा परे रहले
just
एटा मिसिग्रे का संग रखला
13 डाला 27/3
ताले ए जो 2-3 टा ता पूर्वरु रिप्रेजेंटेशन थिला कोन ता परे देखि कंफ्यूज कर बजे
पढ़न से 27/3 ने कोन लिखे
the case record is put up today as the award is Bharat Chandra Mahanta, the present petitioner, and Tulu Mahanta, both sons of Gautama are present in the court today with their London counsel, Sri S.G.M. Burma, who files Baklanda on behalf of his client. They also submit Hazira as to token of their presence in the court. Gone through the case record as per legacy data provided by the RI Kendra, right letter number 7 dated 11/11/2022. Bharat Chandra Mahanta and Tulu Mahanta.
Bharat is the present petitioner.
And Tulu Mahanta, both sons of Gautama, are the sole owner of the acquired property and are entitled to receive a sum of ₹701 only as compensation in lieu of their landed property as per the award statement attached here in the case record. The award is signed the same along with the indemnity bond undertaking and handed over possession of the case land to this court. But they signed the CC voucher with objection as they are not satisfied with the compensation amount. They are allowed to go to do so as per section 3G5 of the National Highway Act 1956.
Our amount of rupees 701 only as compensation to Bharat Chandra Mahanta, Tudu Mahanta, both sons of Gautam Mahanta is hereby confirmed. In absence of the NHI policy number, in adherence to the NHI policy circular number such and such, dated 21/2/2022, all payment of LA compensation to the land users will be made through Bhumi Rashi portal in project financial management system. As such, the awardee has provided their bank account, which is attached to this case record and forms a part of it. The award amount is to be transferred to this bank account. Ask DO of this office to enter the legacy data in Bhumi Rashi portal and report compliance. Thereafter, the petitioner received that amount and my lord, and on 5/12/2012, जो representation डाली था, सेटअप से consider कलम to evaluate the valuation of the house matter. That is the sole grievance.
ଅର୍ଡରଟା ତ ଆପଣଙ୍କ ଏଗେନଷ୍ଟ କରା ଜାଣ ସେଇ ଅର୍ଡରଟାକୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ନା କଣ?
नहीं এইটা তো আমি তারপরে টাইম টু টাইম অথরিটি রিকোয়েস্ট করছি ଆମ ଘରଟାକୁ ଭ୍ୟାଲୁଏସନ କରାଯାଏ ସେଇ ଜିନିଷଟା ଏଠି ସେ କିଛି ମେନସନ କଲେନି ଆଗରୁ ଯୋଉଟା ଆମର ରିପୋର୍ଟ ଥିଲା 5/12/22 ମୋ ଘରଟାକୁ ଆଉ ଥରେ ଭ୍ୟାଲୁଏସନ କରାଯାଉ ଯୋଉଟା କି ଆକ୍ୱାର୍ଡ ବାଇ ଦି MHI that has not been done. That is the sole grievance before us. ସେଟା ଘରଟା ହେଇଛି as per annexure 6 page 19 mile. The junior engineer submitted the report, prepared this report at the instance of petitioner. He requested and land. ଆଗରୁ ଆମେ 5/12/22 5/12/22 ରିପୋର୍ଟ ଆମେ ଦେଇଛୁ 5/12 ଦେଇଛୁ ସେଇଟା 17/12 ସେ ମିଟିଂଟା ସେଇଥିପାଇଁ ହଁ ସେ ଆଉ ସମସ୍ତେ ସେଠି ସାଇନ୍ କରିଛନ୍ତି 4 ଜଣ ଆଜ୍ଞା ତ୍ରିଲୋଚନ ମହାନ୍ତ ରେଭିନ୍ୟୁ ସୁପରଭାଇଜର ସାହାରପଡ଼ା ଆଉ ଗୀତାଞ୍ଜଳି ମହାନ୍ତ RI ତେନ୍ଦ୍ରା ରବିନାରାୟଣ ସାହୁ ତାପରେ ପୂରଣ ନୀଳିମା AE NH ସବ୍ ଡିଭିଜନ ଥାର୍ଡ ପୂରଣ ନୀଳିମା ପାପୁ AE NH ସବ୍ ଡିଭିଜନ କେଉଁଝର ତାପରେ ASI ପାଟନା PS ASI ଗଜେନ୍ଦ୍ର ପ୍ରଧାନ ଅମିନ so many persons of government officers are present there.
The petitioner has filed this petition with a prayer for a clarification for evaluation of the acquired land and house situated over khata number so lekhaiji fair the mauja numbers district so of the petitioner and to give actual compensation with proper valuation of the land and house to the petitioner. The land council for the petitioner drew the attention of this court to the order dated 27/3/2023 passed by the CIL Tahsildar Saharpada, in which it appears that award amount of rupees 701 only was paid as compensation. The petitioner, as well as his brother Tulu Mahanta, and The Land Council, the Land Council for the petitioner submitted that there was a single-story residential building over the said plot, which was constructed in the year 2019, and the valuation has been made by the junior engineer, and the cost of the building would be 36,22,328
Valuation at the instance of the
balance, which was made at the instance of the petitioner.
That is not B. That's just B schedule. A schedule for the petitioner. B schedule 36 for the his father in another house. A B দুইটা categorize করা আছে। তো 31,000 যেটা B just B র উপরে যেটা সেটা হচ্ছে petitioner। 31,000 লক্ষ 14,000।
আচ্ছা, এটা দুইটা করে ওটা হচ্ছে 31 লক্ষ আর ওটা হচ্ছে 36 লক্ষ না
36 লক্ষ যেটা সেটা ফাদার আর তার সেটি ঘর
আচ্ছা এটা হচ্ছে তার লিখলাম এটা হচ্ছে 31,14,987.06
after depreciation of this after depreciation of 5 years depreciation of this লক্ষ এই right side লিখলাম
right, and the said amount has not yet been paid. So notice on the question of admission indicating therein the matter shall be disposed of at the stage of admission. State Council accepts notice on behalf of all the opposite parties. Matter will be listed. Extra copies to be served. Matter will be listed after 4 weeks. Counter affidavit if any be filed in the meantime. এই যেটা বাকি যেটা রহিলা ସେଥିପାଇଁ কোন ଆଉ ଗୋଟେ কেস କରିଛନ୍ତି রিট পিটিশন କାହିଁ ସେଟା
147 ସେଟା ଆগে ହବା କଥା ଏଇଟା ଆগে ଦେଇଥିଲି
ସେଟା ଆଗରୁ ହେଇଯାଇଛି
ନା ହେଇନି 1471 ସେଇ ତାର ବାପା ଅଛି
ତାପରେ ସେଟା ଆଜି ଲିଷ୍ଟରେ ଅଛି
ଆଜି ଲିଷ୍ଟରେ ନାହିଁ
ଆଚ୍ଛା alright
we are now issued notice under annex 5 for to vacate the land. I have filed mistake to for successful.
No question of status. So you have to, if you let them file the counter affidavit, we'll see that.
Sunday.
Yes. We are fixing the date 4 weeks. Date they were Sunday or they will fix up. Yes, next.
Item 22.
Similar to item 19 million.
Similar to item 19.
Annexure in this case, annexure 4 is pending if OP5.
19 making dictation of me. Say type of regulator 22,000. They are connected only and by. Yes.
Pattern item number 15 minor. If the DS input and motor is yield minor, that's why the income that I have mentioned matter within the house.
It was passed over. You want adjournment?
Yes, district mention immediate.
Alright. Mention is made on behalf of Mr. Deepak Ranjan Sundar for adjournment. Please this matter will be commenting hard of April 2020. Item number 15, huh? Yes.
Item 23.
Item 23. We have filed the IA number 8189 of 2024 at flag D minutes for substitution of the respondent number 1 minute. Respondent number 1 died on 31/8/2022, and it was.
Who has filed this IA?
Well, the appellant, the state.
The state has filed.
Yes.
So,
flag D may kindly be seen.
There are how many opposite parties here?
The sole respondent number 1,
right,
who was the petitioner in the writ petition.
IA number so and so. There is an application for substitution of deceased respondent number 1. After hearing the Land Council for the state, going to the amendments made in the interim application. The prayer made in the interim application is allowed. The legal heirs of the deceased respondent number 1, whose names signed this as respondent in the schedule of the IA. The terms are be added as respondents number 1A, QC, 1B in case of respondent number 1. Consolidated, you are to file it
Yes,
with first title you are to file.
Yes, sir.
First title we file within a week.
Yes, ma'am.
Within a week.
I'm obliged.
এইটারে সেটা ফাইল করে দিলা পরে কন্ডোনেশনের নোটিস ইস্যু করিও যেটা বর্তমান সাবস্টিটিউশন টাইম হয়ে গেল তারপরে এই যে কন্ডোনেশন ফাইন
We are substituting without notice. At their own risk.
নোটিস তো হয়নি
Allowing it, and at their own risk, not revealing it. After substitution, allowing it. I mean, it's taken.
So this matter has not yet been. This matter notice has been issued.
Yes, ma'am. Lord Shima, kindly 12/4/23 order. Order number 1.
No, has notice been issued to the legal heirs?
No, ma'am.
No,
After
Proposed
substitution,
legal heirs. Yes.
beg your pardon, Lord Shima.
Has notice been issued to
No.
the proposed legal heirs?
No, ma'am.
So they have to file it in this delay condonation matter and notice you.
No, the substitution also usually can notice appear no objection.
Next.
Item 24.
I the application. The meantime, we have to apply the direction of the government tribunal.
Okay, I is for withdrawal, disposed of or withdrawn. Yes, next. Thank you.
Item 25.
This I will not hear.
Which one?
This item 25 from other bench.
Right. It is this matter before some other.
I'm appearing for appearance. So nothing can record my appearance and on being transferred to me, I am appearing now.
The reason.
No, I'm appearing for the seal also, Union of India.
Yes, yes.
Earlier, Mr. MP Singh was appearing. Nothing to me. I got the NOC.
Mr. Storoj Kumar Das and his associates have filed power. Or
For the appellant, the appellant. For the appellant.
Item number 615. For the appellant. Is taken on record.
And for rejoinder, my lord, so you will not be earlier directed to file rejoinder and
Let me extend the time.
I can't hear this matter, so all these orders can't be passed.
Only this we are taking up, then we are. Put up this matter, you put to answer, no? Yes.
Item 26.
Lordship, in item 26, we have filed an additional affidavit, Your Lordship, and the counsel for the central was supposed to file a reply to the additional affidavit. During pendency of the case, there was some development.
Yes.
Mr. Here, the petitioner had challenged the input judgment passed by the Land Central University Tribunal Cutoff Bench, Your Lordship. During pendency of the writ petition, there was some development, Your Lordship, regarding their pay scale allowance. To that effect, the petitioner had filed an additional affidavit, Your Lordship.
Yes.
The counsel for the central was supposed to file a reply to that affidavit, Your Lordship.
Mr. Pahi,
Yes, my lord.
an additional affidavit has been filed by the petitioner. And have you received it?
What does this say? Sorry, my lord, the file is not misplaced. Lakshmi, some of that I will check it.
What do you want now?
Give me 1 week time, madam. Next week, any day.
Last time this matter was taken up on 13/11/2023, and the time was taken for filing reply to the additional affidavit. But
Might have done
you
with
not filed the reply, but you say now the file is not there with you.
No, not there. It's misplaced, my lord. It will be fine, definitely. Not somewhere it is.
All right, Mr. Pari, Land Council, appearing for the Union of India, seek some more time to file the reply to the additional affidavit filed on behalf of the petitioners of this matter. Let it come on 3rd of February 2025. You press out your file.
Yes, madam. Yes, madam. Yes.
Yes. Like, along with your WPC connected.
Mr. Shaw, yes.
Item 27.
27, your lordship directed for filing a written note minutes. I have prepared it. I have served a copy to my learned senior. I'm filing it. Written note.
Where is that?
Plus, I'm just filing it.
And you have handed over a copy to Mr. Ross?
Yes, sir.
Yes, just now he has handed over.
So what both of you want, sir?
Lordship, may fix it for hearing minutes.
Well, actually, this is for hearing.
Yes.
You just may have it any time in the first week or second week of February.
Against the order of the learned single judge, what the order was passed by the learned single judge?
The persons those who have been appointed by the university, a direction was given to regularize their services.
Okay, you are for the?
I am for the employees those who have been appointed whose services are to be regularized. And we have been continuing for the last 25 years.
Okay, state has challenged it.
Yes.
State has challenged this.
On what ground you are
On
challenging
the ground that the appointment is illegal, although they have served for a substantial period, the appointment was done without the permission of the government. That is the sole ground, Mills. And Mills, although the principle of Uma Devi has been relied upon by the Honorable Single Judge Mills, that will not applicable to this case. This is the ground of the state, Mills.
Recently, also another decision has come.
Yes, Mills. So, I have taken print out of this, Mills. I have not mentioned the judgments here, Mills, only the grounds. As on the date of hearing, Mills,
Judgment mentioned that you want to keep something secret.
No, nothing secret. I cannot keep anything secret from my learned senior. That's a Lordship is directed to file the written note anyhow because state has taken several dates for filing the written note. So I have prepared the written note. Lordship may fix it for hearing minutes. Will also.
No, the thing is that if 25 years somebody is serving
Yes,
a particular organization,
my lord.
you have availed the services and cannot say that there was no requirement of such post. That was the thing which has been considered in the recent
Recent,
decision.
yes, I have read
interpreting that.
my lord.
So even if it is can say it is an irregular manner it is done,
Yes,
but that also one of the important
Yes.
criteria which is to be taken.
But here, my lord,
So
another
after availing the services for 25 years, if you just throw the employees, then what they will do? Like they have passed that age, now they cannot apply. So, and in these matters, if the state is challenging, then what will happen? Then
I am conscious of that.
see, see, case is not of an individual.
Yes,
If you are keeping such type of person in employment, they will also think twice before taking up the services that why will serve for so many years if there is no guarantee that will be regularized at any point of time and the state will come up and challenge our after 20 years.
Right.
So it is an illegal matter is something different, but irregular way down, but they have got the qualification, they have served you,
yes.
and that too for 25 years. It's
Right.
not a small thing.
I stand corrected
Well,
15 years.
15 years.
15
all
years.
right.
There are certain technical
Because the
difficulties.
appointment was made in the year 2011.
All right. The Land Council for the state has filed the written note of submission, which is taken on record. Copy of the written note has already been served on Mr. Jayant Kumar Rathi and senior advocate appearing for the respondent today in court. And he seeks some time to go through the same of this matter. In the week commencing from Mr. Ross, when will you take up this matter?
Anytime I was met, sir, I have no
So
problem.
let it come on then
As
10th
your
of,
lordship.
10th of February 2025. Yes.
Yes.
Mr. Rath, you are not aware of the decision? I don't believe.
This is very much I'm trying.
It has a very distinct name. We just type Jago and everybody in the Jago.
Correct. Yes.
Just recently it has been.
I'm reading that matter.
Just a Gawai's decision, sir.
It is in your favor. I mean, somewhat.
Item 28.
I'm looking.
Yes.
The appellant is challenging the keeping order related for treasury as by the new single judge. It is on page number 37.
You have lowered your voice to such an extent that it is unable to hear. इतने कम साउंड रे पहले केमती कौन करा दियो
ନା ଆପଣଙ୍କୁ ଶୁଭୁଛି ଆପଣଙ୍କ ଭଏସ
कौन असुविधा ही जी आज
ନାଇଁ
अरे सुबुनी ना मु एते कम वॉइस रे कहउछन
ମାଇକ୍ରୋଫୋନ ଟା କୋଉଠି
नहीं सर वॉइस टा ଟିକେ कम आछी वॉइस टा ଟିକେ कोड को वॉइस टा ଟିକେ
ଟିକେ ଘୁଞ୍ଚି ଯାଆନ୍ତୁ ନା ସେଟା ଟାଣନ୍ତୁନି
जो काउंसिल अछि सेमान को हमहु तो सुबुनी सेमान को सुबुनी आई म डाउट यस प्लीज
here in this case the appellant is challenging the order of the honorable single judge that is on page 37 here.
Yes.
The order reads for the civil nature of the dispute involved herein, the writ petition is not maintainable in the eyes of law, which is hereby dismissed. However, if the petitioner is so advised, may approach the civil court. The actual matrix of the case, my lord, the opposite parties are
What is your prayer in the writ petition, which has been had to be a civil nature of dispute?
compensation
My lord, they are
Let us come.
occupation of my body. They are
नहीं आपनकर writ petition रो कॉपी देइछंदी
आज्ञा
हां पळे आसुन कोन पई कोर्ट कले ये एटा गोटे सिविल डिस्प्यूट हो
It's a private land. The opposite parties are in
area rent.
Yes, ଆପଣ prayer portion को आसुन.
their person of the read.
हाँ, read ର. ଯୋଉଟାକୁ କୁହାଗଲା ଯେ ଏଇଟା ଗୋଟେ ସିଭିଲ ଡିସ୍ପ୍ୟୁଟ ଟାଇପ ର ଅଛି, ତେଣୁ ରିଟ୍ ଏଠି ମେଣ୍ଟେନ ହବ ନାହିଁ ଇଣ୍ଟରେଷ୍ଟ.
The prayer is at page 23 of the
It is therefore must humbly prayed that considering the facts and circumstances stated above, this honorable court may graciously be pleased to admit the writ petition, call for the relevant record as deemed fit and proper, and after hearing the parties upon notice, directing the opposite parties, especially the opposite party number 1 and 2, or any other opposite parties, to pay a sum of rupees 1,44,000 calculated as on 13/3/2018 towards arrear rent as assured by them from the date of their illegal accusation till its payment, and further directing the said opposite parties to pay the monthly rent amounting of rupees 300 per month regularly in each succeeding month, or in alternative directing the authorities opposite parties to pay compensation in respect of the land of the petitioner illegally acquired by the electricity department.
Rent the
Your Lordship, if I may appease,
Yes.
Your Lordship, the matter relates to shifting of transformer. The transformer was allocated, situated on their plot, and the dispute arises from there. But the same has been decided by the division bench of this lordship that the same may be referred to district magistrate or the collector.
Where it is decided?
If I may,
Person.
Lordship, there is an order. Similar matter, Your Lordship, where there was there was already a transformer existing on the plot. Wherein only the division bench of the court had already held that the district magistrate or the commissioner of police are authorized to advocate on the matter of the shifting of transformer and the compensation arising there. If Your Lordship, there is a paragraph number 35 in judgment. If I may read it out, Your Lordship.
So has he approached for shifting of the transformer? He has approached the court for payment of area rent. So how is this decision applicable?
Your Lordship, if you see the letter, the representation that they have approached us, they said that for the illegal acquisition of the transformer over the said lot, and they have
Acquiring a transformer?
They have alleged that we have set up a transformer on their plot for which they require rent.
So that is a civil dispute which the court has rightly rejected.
Yes, sir.
Alert of the appellant here is an old person of around 82 years old, and he'll be compelled to go to the civil court to take another period. I have
एज क्राइटेरिया अछि एतिकी बयस हिगले आउ सिविल कोर्ट न जायकिनी हाई कोर्ट डायरेक्ट आसीबो आपण सेगुडा के एंटरटेन
I have made a prayer for the rent, but in my notice also I have given representation that
ଆପଣଙ୍କର ଜମିଟାରେ ଗୋଟେ ଟ୍ରାନ୍ସଫର୍ମର ବସିଥିଲା ତା ପାଇଁ ଆପଣ ମାଗୁଛନ୍ତି ବର୍ତ୍ତମାନ ଭଡା ମତେ 300 ଟଙ୍କା ଲେଖା ମାସକୁ ଦିଆଯାଉ ଏଇଟା ମାନେ କୋ ଇଏରେ କେମିତି ଡିସାଇଡ ହବ प्रथम तो डिसाइड हम आपन जमी रे से ट्रांसफॉर्मर बसतिला कि नाही सेटा को एडजुडिकेट हवा दरकार हला द्वितीय कथा भड़ा पई तो किछि गोडा एग्रीमेंट नाही तेणु सेटा गोटे डिस्प्यूटेड जिंस भड़ा देबे कि न देबे हाई कोर्ट रे केमति गोडा डिसाइड हो
ए आमे मना करनु जे आपनको किछि माने
property right ମୋର ଅଛି
property right ଟା we can't decide in a writ petition. This is the problem.
କୁହାଗଲା ଯେ ଏଟା civil right ଆସୁଛି
I am submitting
civil court ରେ
my lord some order of this honorable court where my lord the honorable court has
ସେ କୋର୍ଟ को ଦେଖେଇଥିଲେ सिंगल बेंच को ऑर्डर ଦେଖେଇଥିଲେ
I don't know ସେ ସମୟରେ ଦେଖିନି
so what is wrong with that order and ସେ transfer ଟା ଏବେ ଆପ ଜାଗାରେ ଅଛି ନା ଏବେ ନାହିଁ
ଏବେ still continuing
Can you approve
there is
the
position
proceeding?
ତ
That
ଯଦି
we can direct.
ଏଠି ଗୋଟେ ଆପଣଙ୍କର ଫାଇଲ କଲେ ଆପଣଙ୍କର ସିଭିଲ ସୁଟ୍ ଟେ ଫାଇଲ କଲେ appropriate order ହବ ଯେ ପ୍ରକୃତରେ transformer whether it is in existence in your land or not
ଯଦି if the
ଏଗୁଡାକ
opposite party is
ବହୁତ
denied that
ବଢି-
it's not
କାହିଁକି
installed
ଜଣେ ସିଙ୍ଗଲ ଜଜ୍ ବେଞ୍ଚ କହିଲେ ଯେ ଏଟା ସିଭିଲ ଫୋରମ ରେ
civil
ଆସିବ ବୋଲି
property right earlier also this honorable court has decided I am submitting my lord
ଆପଣ ଯୋଉ ଭଡାଟି ମାଗୁଛନ୍ତି ସେଟା ପାଇବାକୁ ହେଲେ ତାର କେତେ ଗୁଡାକ ଜିନିଷ ଦେଖିବାକୁ ପଡିବ ଆଗେ ଯେ ଆପଣଙ୍କ
Alternative-
ଜମିରେ ସେ ଟ୍ରାନ୍ସଫର୍ମର ବସିଛି ଅନଅଥରାଇଜଲି ବସିଛି ତା ପାଇଁ କୌଣସି ଭଡା ସରକାର ଦେଇନାହାନ୍ତି ସେଥିପାଇଁ ଆପଣ ଏସବୁ ଜିନିଷକୁ ତା ପାଇଁ ସାକ୍ଷ୍ୟ ପ୍ରମାଣ ଦରକାର ଯୋଉଟା କି ରିଟ୍ ର ଜୁରିସଡିକ୍ସନ ରେ ସମ୍ଭବ ନୁହେଁ ସେଇଥିପାଇଁ ଜଣେ ସିଙ୍ଗଲ ଜଜ୍ କହିଲେ ଯେ ଏଟା ସିଭିଲ
ସେମାନେ ତ
କୋର୍ଟରେ
deny କରୁନାହାନ୍ତି କି ମୋ property ନାହିଁ ବୋଲି
shifting of ये से clause अनुसार अच्छी ठीक है नौकरी को लेकर कोर्ट को होगा shifting मांगना है
$44,000 towards area rent from the date of illegal acquisition till its payment with a further direction to pay monthly rent amounting to rupees 300 per month regularly in each succeeding month or in the alternative directing the said opposite party to pay compensation in respect of the land illegally acquired by the electricity department and to set aside public modify the order passed by the land and single judge in WPC number so hide order dated so. The writ petition was filed by the petitioner with similar prayer. And in the writ petition, the government has been taken, paragraph 2 government from the paragraph relevant government. The land and single judge, as per the improved order, has been pleased to hold that since the dispute is civil in nature, the writ petition is not maintainable, and the petitioner was given liberty to approach the civil court. The land counsel for the petitioner has failed to point out the illegality in the impugned order passed by the sworn show. And after going through the averments made in the writ petition and hearing the learned counsel for the petitioner, we also find that the dispute is basically civil in nature. And stop. The learned counsel for the petitioner has produced.
I see about it. He's trying to help. What
The
is your name, madam?
Ruprekha Jana.
so appearing, you are appearing for whom?
Opposite party.
Opposite party number? All the opposite party.
Are you saying that he has alternate remedy? What is
Sir.
your submission?
He may approach the district magistrate.
Opposite parties cited the decision of this court, division bench decision of this court, in the case of executive engineer electrical so and so versus Saubhagini Patro, reported in 2023 to ILR Cutter so and so, and submitted that the petitioner has got alternative remedy.
Appellant.
The appellant has got alternative. Considering the submission made by the Swansea,
Dismissing the
we don't find any merits in the writ appeal and or any infirmity or illegality in the order of the land single judge. Therefore, the writ appeal stands dismissed. It is open to the petitioner to approach the appropriate court
authority
seeking appropriate remedy. Accordingly, the writ appeal stands dismissed.
With the aforesaid observation.
The aforesaid observation.
Yes, Gala.
Rest of the matter 36. You can come on Monday.
But in item 36, we are filing an application for implement. Tell sir the copy on my learning CV.
36, what do you want?
But in item number 36, we have filed an application for implement. I'll sir the copy of the same on my learned senior.
Today, actually, let the implement be allowed.
We'll take up this matter on Monday. What is there? Is there anything urgent in that?
No, that's it.
All these matters will be taken up on Monday. Okay.
Pattern to make life. Conviction under section 302 IPC sentence for life, the appellant is in custody more than 11 years.
But item number 32, I have filed two states, my lord. One is reelection file and one is bail, my lord. Is a lady, aged about 67 years, is in custody.
No, I'm mentioning we can see it in the hearing list.
Hearing list too. Also,
All right, we'll see that.
I have 32.
In worship item number 30, state for an adjournment.
What is that?
Item number 30, PRLA 160 of 2009.
You're praying on behalf of whom?
Religion Pandey.
Then you should say there are two matters. You are the appellant in the second matter.
Yes, worship.
Hearing matter, जल्दी गुट्टे ही वाला भी चौड़े देखियो मैडम
केबे नेक्स्ट वीक दरकार ना केबे से थाउ से मन कोन आसीबो नै
यस
Supplemental list, item number 1.
My lord, appellant convicted on the section 302 34 RPC and the fine amount is 10,000 and the 323 IPC 1 year proceeding period of 1 year
life imprisonment.
My lord,
I admit for
I stay fiction my lord.
stay relation of mine. Yes.
Item 2.
There is a petition for condonation of delay. What? How many days delay is there?
council is not valid.
So 1313 दिन. You do one thing, you file your just formally objection you file because it is 1313 days. There's life imprisonment. But since the delay is 1313 days, IN number so and so, there is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 1 to 5 days in filing this criminal appeal, and counsel for the state section plan to file objection to the interim application. It is this matter and we commencing on 10th of February 2025. Objection, if any, be filed in the meantime. It should be placed for consideration of the application for condemnation of bill. Yes.
Item 3.
And I am on behalf of Suryakant Trivedi. This matter, the offenses are 376 plus 3, 376 DA, 4 plus IPC, and 4 plus 2, and 6 plus 1 of POCSO Act. And punishment are the dangerous imprisonment for life. Notice mentioned.
What are the offenses here?
376 plus 3, 376
DA,
IPC, and 4 plus 2.
Or admit
6 plus 8.
call for the trial court report. Since one of the offenses, since the offenses are under section 376(3) and 376(d) of the Indian Penal Code, extra copy of the appeal memo along with the interim applications be served on the line counsel for the state, which will be sent to the IIC of Piringia police station for its service on the informant. Baki usual order further. Same order be passed also in this other 1336, and both the matters should come together. Both will be admitted.
So total the case will be list with this, or a list with this,
Ah.
the tag will be
Yeah, there will.
Item 4.
May I please, Your Lordship? Your Lordship, the present appellant has been convicted by the Learned District and Session Judge Kendrapada for offence under section 302 IPC, along with sections 148, 307, 506, and section 149 of the IPC. So,
yes.
And there we have preferred the criminal appeal. There is a delay of around 17 days.
Do you hold power in this case?
Yes, yes.
What is your name, please?
Ayushman Singh.
Ayushman.
Yes, sir.
When you joined the practice?
Nearly around 3 months ago.
3 months ago.
Yes, sir.
All right. Heard Mr. Ayushman Singh, Land Counsel for the appellant, Land Counsel for the state. There is an application for combination of delay. The stamp reporter has pointed out that there is delay 17 days in filing this criminal appeal. After hearing the Land Counsel for the parties and going through the grounds taken in the interim application, and since a petitioner has been sentenced to life imprisonment, we are inclined to condone the delay in filing the appeal. Accordingly, delay is condoned and admit call for the trial. Yes.
Oblige, Your Lordship.
Item 5.
Item 5, Lordship, co-conduct.
Same day delay or
Yes, Your Lordship.
technical target delay করছি
Connected to each other.
same
Same. তাহলে সেই অর্ডারটা কত লিখতে this with that.
the co-accused, so it is to be listed.
Oblige.
Item 6.
The appellant is convicted of 0 to 34 RCC for life ban and to pay fine of 20,000.
There is no delay.
No delay, ma'am. Stay RCC.
So, what is your name?
Manoranjan Das.
Manoranjan Das. Or Mr. Manoranjan Das, Land Counsel, the appellant, and admit for the trial court report. Interim applications for bail and stabilization of fine to be considered after receipt of the trial court report. Deposition copies to be supplied to the Land Council of the state.
Item 7.
Yes, His Lordship. Lord, the appellant has been convicted under section 506 and 34 of IPC and sentenced to undergo rigorous imprisonment for life and fine of rupees 30,000.
What is your name?
Shatabdi Samantra, Your Lordship.
Ms. Shatabdi Samantra. Admit same order.
Samantra, how many years of practice do you have?
Lordship, 7 years.
7 years. All right, next.
Item 8.
Rendered to 123, so far I am concerned, so multiple accused persons are there. I have sought the deposition copies. May I pray the bail application can be considered amid? I will serve the copies to the court also on the date.
My Lord, I'm appearing for the informant, my Lord. And cause appearance, my Lord, other matters are posted to 10/4/2025.
Other matters, mane?
See, multiple accused person, all have been.
So far I am concerned only conspiracy. I will not.
Can you give those case numbers?
My Lord, I have. So it is
in
clear.
this case,
I'll just supply it.
No.
eight numbers of.
Where is your V number?
My Lord, I have already filed. I have obtained receipt also.
When? Today or something?
No, 22/1.
Receipt.
My Lord, 8.
जोड़ा कच्ची connected appeals जोड़ा का tip.
My Lord, I will supply.
Mr. Haripad Mahanti, Land Council submits that he has filed Wakalatnama for the informant. Let the same be placed on record. He further submits that this criminal appeal is connected to Swan. So your number would have it.
Aye.
List this matter along with Swan. So Adil Tatra further admit call for the trial court record. Mr. Sarangi and counsel for the appellant submits that he has supplied the deposition copies to the Swan. Matter be listed every after for consideration of the bail application. IA for bail and Swan. In the meantime,
I am.
Almost individually filed.
All have been convicted for.
All right. I am so far different. 120. I will not know.
अरे ମୁଁ ଆଙ୍କର କରିନଥିଲି ତ କିଏ ସେଟା କୋଉଟା ସେ ପାଢୀ ଜଜମେଣ୍ଟ ଟା କୋଉଠି କର
ବରମପୁର
ଆଚ୍ଛା ଏବେ କର ନାଇଁ 14 ର ସେସନ ଟ୍ରାଏଲ ଅଫ
14 but dispose of
ନାଇଁ ନାଇଁ ସେ ବେଲ ଗୁଡା ନାଇଁ
7th November 2024, my Lord, judgment.
Judgment is not important.
Oh, my Lord, I'm sorry.
The BL, APL गुड़ा को टोटे करते क्या तोले चाहिए नहीं बस ठीक है how next year जाना पड़ेगा facts सारे के लिए मन पड़ जाओ
Lordship. My case is because the other matters are too long.
No, it will come 10th.
Item 9.
भाई 500 appeal admission conviction है कौन life imprisonment आपण 500 वर्ड करिवे तो सेटा कोन उठे पिला उडा आसी छिडा कि करूछनी परा 3 मास रो पिला आपण कर appeal admission ने 500 वर्ड कोन हां से कोन आ
कर्नाटक भी कौन
अबनी रंजन दास
यार
हां मिस्टर
अबनी रंजन on behalf of
Mr. Swan to admit for all for this one interim application for bail and stay relation of time to be considered after the receipt of the trial court. कौन है हाँ
रियलेशन ऑफ फाइल
ये सब कंसीडर हबो ये पर ट्रायल कोर्ट रिकॉर्ड पर ये एडमिशन पे यस नेक्स्ट
Item 10.
May I please your lordship? Lordship, appellant has been convicted under section 30234 IPC and sentenced to undergo RI court life and pay fine of 50,000.
और नाम अपन करो
Chikan Goda.
SK Goda
Plus
SK Goda admit call for the trial court report stay relation of final order बाकी एटा मध्य same order and it is to come along this one so detailed order let's say yes
Item 11.
May I please? Appellant has been convicted for the offense under section 303 of the Indian Penal Code and sentenced to under trial for life.
custody certificate अपन you made a submission on 8/1/25 that you were in custody for more than 17 years.
Release and immediately bail पॉइंटला सेल period.
हाँ ठीक है कितने रही चीज होना
12 years अच्छी 12 years मतलब 12 years 64 Demas.
Okay 12 years. चार हजार 444 बढ़िया दिन हिसाब कर दीजिए 12 वर्ष हो
12 वर्ष 64
what is the prosecution case?
Prosecution case is like this, my lord.
Okay, you come to paragraph number 2 of the judgment.
My lord. The fact of the case is like this. 20/5/2007 the informant Fagulal Patel is the deceased, my lord.
Informant pura informant is the deceased.
My lord. Initially, FIR was registered against the present appellant in an offence under section 341, 323, 325, 506.
Okay.
After 21 days of the alleged occurrence, there was a delay. The lordship may kindly see the alleged occurrence was taken place on 20/5/2007. FIR was registered on 11/6/2007.
Just a minute. Date of FIR la
11/6/2007.
अच्छा डेट के पहला
डेट मतलब 4/7/2007
4/7/2007
मालूम
now you read that paragraph 2 टा जो पढ़ते
मालूम the informant Fagulal Patel, a resident of Rampur Colliery under Rajanagar case, had been to the liquor shop of one Mohan Chadha to consume liquor. After consumption of liquor, while he was about to return home on the road, the present accused assaulted him severely and after lifting him, threw him on the road with much trust. The accused soon after the incident also threatened him with dire consequences in case of any report before the police. The informant has claimed that due to such assault, there has been a damage to his cervical bone and pelvic bone, for which he was not in a position to work. On his Allah, Chandan Patel rushed to the spot and seated the informant to his house. Under this situation, this fact was reported before the outpost.
so Is there any eyewitness to the occurrence?
Though there was eyewitness PW 1 and 13, but the statement is contrary to each other. And the cause of death,
So PW 1 and PW 13 are the eyewitnesses.
Alleged eyewitness.
Oh, hella. So, in what way they have stated that how the assault took place?
As per the version of the PW 1,
Okay.
he is a chance occurrence witness.
अरे बाबू केमिति कोउथरे मारला ताई
ताकू कचाडी देला माने देयर वाज
fist and kick blows.
नो ताकू धरिला और कची देला.
We seek evidence of PW1.
माला running page 17, I know the accused standing in the dock. The informant is my father. The occurrence took place on 20th day of a month in the year 2007 at about 7 p.m. At that time, my father had gone to take liquor. The accused had assaulted my father by fist and kick blow. But in the FIR,
ଆପଣ ପଚାରୁଛି କଣ ସେ କହିଛି ଆଗେ କୁହନ୍ତୁ ଆପଣ ସେତିକି ବି ଧୈର୍ଯ୍ୟ ନାହିଁ ଆପଣଙ୍କର ଆମେ ପଚାରୁଛୁ PW1 କଣ କହିଲା କେମିତି ଆସଲ୍ଟଟା ହେଲା ଆପଣ କହିଲେ କଚି ଦେଲା ସେ ଯେତେବେଳେ ଏଭିଡେନ୍ସ କହୁଛି ଫିଷ୍ଟ ଆଣ୍ଡ କିକ୍ ବ୍ଲୋଜ ଦିଆଯାଇଛି so what about the evidence of PW13?
PW13 my lord, while I came out from my house, saw the incident where both decedent and accused were indulged in altercation. Accused Mohan Raut caught hold of the neck of the decedent and pushed him to the yard.
Okay, pushed him to the yard.
Ma'am.
Who is the doctor who conducted
PW6 is the doctor. PW6 postmortem.
No, doctor ये postmortem कला.
PW6.
PW6 ना 16 ठीक से कौन?
6 मतलब.
6 कला postmortem.
No. 16 was the postmortem, but
6 was the first doctor.
First doctor who was.
अच्छा कौन से देखिला? Refer कला X-ray examination.
I refer him to the higher medical center last 38 page, last 3 line, my lord. I refer him to the higher medical center as there was dislocation of bone of cervical spine. And at that time, the patient was under paralysis of 4 limbs. Exhibit 1 is the bed head, come referral ticket, and exhibit 1 by 1 is my signature.
Septicemia coaching last go.
Last the cause of death may be due to septicemia due to cardiorespiratory failure.
And how would you doctor you?
PW16 mala.
हाँ, ठीक कौन करेगा?
He has stated that the fracture of cervical bone may not be sole cause of death. I cannot say whether the patient was given proper treatment. The cause of death is due to septicemia. The patient may not have provided with proper treatment.
So you mean to say that there was gap between the date of occurrence and death, number 1. Number 2, there are 2 eyewitnesses. One says it was given by countries. The other say he was pushed to the ground during altercation. And
third one is though the PW9 has stated that he has wrote the FIR. He has stated that at the relevant time the deceased was in his house.
ଦିଥର କଣ ଆସିଥିଲା ଦିଥର ଆସିଛି କଣ ଡାକ୍ତର
ଗୋଟେ ପ୍ରଥମେ ଇନିସିଆଲ ଡକ୍ଟରଟା
ନା ଏଇ ଡାକ୍ତର ହି PW6 ଆଗ ଆସିଲା 21/5 ରେ
ସିଏ ପ୍ରଥମେ ଆସିଲା
injury on his face and neck first aid ଦେଇକି ତାକୁ ଛାଡିଲି
ତାପରେ ବୋଧେ
ତାର dislocation of cervical ତାପରେ
13 ଛୁଆ ଆସିଲା ପରେ ସେ ତାକୁ
20 ଦିନ ପରେ
SCB ରେଫର କରିଦେଇଛି
ସେ କିନ୍ତୁ ପଳେଇ ଆଇଲା ସେ ଫେରି ଆଇଲା ଫେରିକି ସେଇଠି ଆଡମିଟ ହେଲା ସେଦିନ ମରିଗଲା
ତାପରେ ମରିଛି
ସେଦିନ
4/7
ନା 13/6
ନାଇଁ 4/7
he came back to serious problem was admitted attending cause of injury, he died.
ପାଞ୍ଚରେ postmortem କରିଛି
ଆଚ୍ଛା
PW6
I attend him
39
that
page
day.
ରେ କହିଛନ୍ତି
ନା ଏଇଟା ତାହେଲେ କ'ଣ? He came, ଦେଖନ୍ତୁ
PW6 ତ
he came back and due to serious problem he admitted in central hospital. ତାପରେ I attend him on that day and found he was on dead. ତାହେଲେ କୋଉଦିନ attend କଲା ତାକୁ? After getting treated at SCB medical he came back. And due to serious problem he was admitted in central hospital.
again ବୋଧେ admission
ଯୋଉଦିନ admit ହେଲା ସେଇଦିନ ମଲା. I attend him on that day and found he was dead. Blunt trauma.
Yes, Mr. Nayak, what do you say? Cannot be a case under 302. Slips and kick blows. ଜଣେ କହୁଛି ଆଉ ଜଣେ କହୁଛି ତାକୁ ଗୋଟେ ଧକ୍କା ମାରଲା ତଳେ ପଡିଗଲା there was fracture. ସେଠି ଆଉ ରହିଲାଣି 12 ବର୍ଷ ଆପଣ ଯାହା ଇଏ କରୁଛନ୍ତି. Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner.
Reject ହେଇଛି ଆଗରୁ ନା ନାଇଁ?
No, madam. After
that the petitioner is in judicial custody more than 12 years. The learned counsel for the state has also produced the custody certificate issued by the senior superintendent Circle Jail Sambalpur dated 14th January 2025, which also substantiate such aspect. Stop. The land counsel for the petitioner submits that the deceased Falguna Patel is the informant in the case, and he lost the first information report before the IAC of Brajaraj Nagar Police Station on 11/6/2007 relating to an incident dated 25/2007 in which he implicated the petitioner to have assaulted him, for which a case under section 341, 323, 325 and 506 of the Indian Penal Code was registered. And the deceased died on 4/7/2007. Though there are two eyewitnesses to the occurrence, that is PW1 and PW13. Though PW1 has stated that the petitioner assaulted the deceased by fist and kick blows, causing fracture of the pelvis bone, but PW13 has stated that there was an altercation between the appellant and the deceased, and the appellant caught hold of the neck of the deceased and pushed him to the earth. The land council submits that the doctor who treated the petitioner at the first instance is also the doctor who declared him dead, and that is PW6, and he has stated that the cause of death was due to septicemia, cardiorespiratory failure. It is argued by the land counsel for the petitioner that taking into account the background of the case and the postmortem finding, it cannot be said that the ingredients of the offense under section 302 IPC are satisfied. And since the petitioner has already remained in judicial custody for more than 12 years, the bail application may be favorably considered. Land counsel for the state who's the prayer for bail place the evidence of PW1, PW13, PW16 and PW6 and PW16. considering the submission made by the land council for the respective parties, nature of evidence adduced during trial, uh, surrounding circumstances under which the offense alleged to have the occurrence stated to have taken place, the post-mortem report findings, the period of detention of the petitioner in judicial custody, we are inclined to release the petitioner on bail alone. Obliged.
Item 12. Item 13.
I have filed an IA number 21 of 2025 matter. That is
For what?
for bail matter.
Have you served a copy on the state council?
No matter, I will solve.
What is the number? Please tell once again.
IA number 21 of 2025 matter.
केबे फाइल कर ले?
Aji करछी.
वो आज ही करछी.
Well, I am serving in the court.
Right. The Mr. Sahoo, Planning Council for the appellant submits that today he has filed an interim application for bail of the appellant, and the same has been numbered as IA number 21 of 2025. He served a copy of the interim application to the Land Council for the state in court. So, are you having those deposition copies?
Yes,
with
my
you?
lord. I have got them.
Mr. Nayak? नहीं यदि एटा जेल क्रिमिनल अपील तो अपन पर अच्छी देखो अच्छी तो it is this matter in the week commencing from 3rd February 2025 for consideration of the bail in IA number one. So, hello? Yes.
Item 14.
All right. IA number one. So, this is an application for bail. The Land Council for the appellant handed over the deposition copies. The Land Council for the state in court today to seek some time to go through the same. Please this matter in the week commencing from 3 to 2025. Yes.
Item 15.
Sulochana Patra. তিনটা আগে রয়েছে কি অপশনটি রেডি?
My lord. Item 19, I will conduct my lord.
Item 19.
My lord, item 18 I will do.
More would
ଆପଣ ଦି ଜଣଙ୍କ ଭିତରେ ଟସ୍ କରିଦିଅନ୍ତୁ ଜିତି ବସି ଆଉ ଯଦି ଶୋଲେ
Item
ଭଳିଆ
number
ଟସ୍
two.
ହେଇଗଲା ତାହେଲେ ଅସୁବିଧା।
my lord. Item number 18 ଟା ମୋର ଅଛି
18ଟା ହଉଛି
18ଟା ମୋର ସେଠି ମୁଁ ସେଇଟା
19 ଭିତରେ ଦେଖାଗଲେ 18ଟା ହବା ଉଚିତ।
ମ୍ୟାଡାମ ଆପଣଙ୍କର 18 ନୁହଁ my lord my item is 17 ମୁଁ ସେଇ ଜାଗାରେ 19 ଟା କରିଦେବି
ଅପେକ୍ଷା କରନ୍ତୁ ଲେଡିଜ ଫାଷ୍ଟ କୁହାଯାଏ ଆଜିକାଲି ଲେଡିଜ ମାନେ ବହୁତ ଭଲ ପରଫର୍ମ କରୁଛନ୍ତି ଓଜିଏସ୍ ରେ ଏବଂ ଅନ୍ୟାନ୍ୟ ଇଏ
in this case my lord
302 case.
my lord the initially case was registered under section 498A 302 304B 34 of IPC reduced section DP of
So the
458.
allegation is killed your wife. That is
Yes, appellant husband killed his wife.
You come to the first information report.
You prepared a note or a date chart or anything? No, I have not typed. I have all right. No, if you have, yes. ଆମେ ଏତଲା କରି
Page number
page
29.
29.
पढ़ो
आमे इतला करी श्री प्रदीप कुमार पात्र उर्फ अमूल्य
कित नंबर सखी
विटनेस 10 मैलर
PW 10 अच्छा पढ़ो तू
जनाऊँ कि जिला भद्रक जनाऊँ कि आमे आमर सान भौणी श्रद्धांजलि पात्र को गछडिया ग्राम
श्रद्धांजलि पात्र इज द डिसीज्ड इन दिस केस
गछडिया ग्राम निवासी सनातन दास ज्येष्ठ पुत्र श्री सुरेंद्र दास सहित
सुरेंद्र दास होजन
Appellate.
appellate
सहित गत आषाढ़ मास रे वैदिक रीति रे विवाह देथिल दैट इज 2009 मैलर आषाढ़ मास 2009 अगस्त 2009
तो आषाढ़ मास माने अच्छा हो ठीक है
विवाह समय रे आमे
नहीं आपको जस्ट
एटा ऑकरेंस टा हेची 2010 रे
हां 2010 रो एतला हेची नवेम्बर मास रे
आगे
तो आपण केमिति कहउचंती 2009 आषाढ़
आषाढ़ मैरिज
नहीं नहीं सी पहिला गत आषाढ़ मास रे गत आषाढ़ मास रे तो 2010 रो भी आषाढ़ क्रॉस कर जाई तो नहीं हाउ ही सीज टेलिंग दैट इट इज
जजमेंट रो ये रे लिखा है 2009 बोली फर्स्ट पेज रो जजमेंट
हेई थिबो किंतु गत आषाढ़ माने तो सेही वर्ष रो आषाढ़
आषाढ़ 2009 बोली लिखा है
नवंबर मास रे नहीं जदि कि ओरल एविडेंस देई थी अलगा कथा किंतु गत आषाढ़ व्हाट डज इट मींस दैट सेही वर्ष रो सेम ईयर रो माने आषाढ़ मास मे बी अगस्त सितंबर की सॉरी हां गला हां
the first page of the sessions trial
Let us we will find out
all right let's see that please proceed
बापीଙ୍କ सहित आषाढ़ मासरे वैदिक रीति रे विवाह देथिलु विवाह समय आमे पर पक्षर दाबी मुताबक नगद 55,000 टंका सहित चेन मुदी तथा अन्य समस्त वैवाहिक साज सरंजाम सहित जानी यौतुक आकार रे प्रदान करथिलु आम विवाह समय बरपक्ष दाबी मुताबक समस्त साज सरंजाम तथा जानी यौतुक प्रदान करथिले मध्य बाहागर परवर्ती समय मो भौणीर सासू श्रीमती मल्ली दास ससुर सनातन दास
ये माने केही अक्यूज नांती ए केस
ना इनिशियली रजिस्टर्ड हेतला समस्तଙ୍କ नारे
हां तापरे चार्ज शीट हला
चार्ज शीट 302 रे हे गला
नहीं हेला एबो केवल आ नारे पर
आगे
हस्बैंड ना
हस्बैंड ना
हां पढंतु
श्री सनातन दास ननंद रीना दास एवं दियर मुन्ना दास और स्वामी सुरेंद्र दास मो भौणी को अधिक यौतुक बाबद को आउ 50,000 टंका दाबी करी मानसिक यौतुक निर्यातना देउथिले ए बाबद रे मो भौणी श्रद्धांजलि मते फोन रे जणाइथिला एवं मु एही विषय रे मो भौणीर सासू ननंद दियर और स्वामी सहित आलोचना करिथिली सेमानक दाबी मुताबक टंका को मध्य मु धान अमल परे देबा पई कथा देइथिली आवश्यक टंका जनित समस्यार समाधान मु धान अमल पर्यंत स्थगित रखिथिली एथिरे मध्य सेमाने समस्ते सहमति प्रदान करिथिले किंतु बड़ परितापर विषय एही जे अद्य 21/11/2010 रिखरे समय अपराह्न 4 घटिका समय बाहर लोकों ठारू फोन पाई जानिली एवं मु संगे संगे गछडिया ग्राम को आसी देखिली जे मो भौणी रक्ताक्त अवस्था रे मृत होई पड़िथिबार देखिली मो भौणीर सासू मल्ली दास स्वामी सुरेंद्र दास ननंद रीना दास पियर मुना दास मलासुर हगरा सान शशुर परिवार सदस्य मिलित भाव शाबल रे पिटी पिटी मारी देवार जना पड़ुछि तार देहरे कौनसी अलंकार नाही मो भौणी शोइथिबा बिछଣା रक्तरे जुड़बुड़ होइछि मो भौणी को नृशंस निर्मम निष्ठुर भाव रे मारी थिबार स्पष्ट जना पड़ुछि एणु विनीत प्रार्थना करू कि महोदय दया परवश होई उक्त अमानुषिक अद्वितीय विभत्स हत्याकांडर तदंत पूर्वक समस्त आसामी मानक ऊपर दृढ़ कार्यानुष्ठान ग्रहण करने सहित आमको न्याय प्रदान करिवे
so charge was framed only under section 302 not of those charges 304b 4dpr केवड़ा किसी नहीं एवं फाइनल फॉर्म आपण कहउछन केवल आपन को ना ही दिया है
No eyewitness to the occurrence.
eyewitness adhere ପକଉଛିବ ଘର ଭିତରେ ଘଟଣା ହବ
ନାଇଁ
eyewitness
ସମସ୍ତେ ଅଛନ୍ତି ସମସ୍ତେ
ଆପଣଙ୍କ ଘର ଲୋକ ସେମାନେ କଣ ସାକ୍ଷୀ ଦିଅନ୍ତି
ତାଙ୍କ ନାଁ
ଆଚ୍ଛା what is the postmortem report with the doctor
PW1
come to that
page 35 Lordship. On 23/11/2010, I was working as surgery specialist at Chandavali Communist Health Center. On that day, on police requisition, I conducted postmortem over the dead body of one Shraddhanjali Patra, daughter of Prabhakara Patra, late Prabhakara Patra, wife of Surendra Das, village Gachodia, PS Bansada, Bhadra, and found as follows. The dead body was identified by Ramakanta Mia, Pradeep Patra and Rajendra Patra. External injury. Body was sound, hair, complexion, rigor motif absent, liver motif on back, swollen, large blisters from all over body. Application of skin at places, eyes are closed, conjunctive pale, cornea pupils dilated, mouth partially open, tongue swollen and protruded, pical inconsistent, nails were intact, hair intact but easily plucked. Ligature mark was absent. 1. Lacerated wound of left pinna with everted margin. Lacerated wound over left occipital scalp 10 cm into 5 cm with everted margins. Compound fractures of left occipital bone. Under injury number 2 with evisceration of brain matter. Internal injury, compound fracture of left parietal occipital bone 10 cm into anterior posteriorly with laceration and evisceration of brain matter. Hematoma under scalp extending from left occipital region to parietal region. Cause of death, injury to vital organ like brain hemorrhage and shock. Time since death, 40 to 72 hours at the time of postmortem. Approximately Exhibit 1 is my report and Exhibit 1/1 is my signature. 2. On 27/2/2011, the police sent an iron rod to opine whether the injury can be possible by that rod. I examined the weapon and opined that the weapon was a crowbar having length of 6 cm, 2 cm diameter, heavy iron having flattened and sharp at one end and blunt on the other hand. I opined that the injury in Exhibit 1 can be possible by the weapon crowbar produced before me by the IO. Exhibit 2 is my report and Exhibit 2/1 is my signature. Cross-examination by defense. Injury number 1 and 2 are possibly situated. I cannot give
possibly no closely situated.
Closely situated. I cannot give definite opinion. Definite opinion that such injury can be possible by fall of beam. Lacerated can be possible if a hard and blunt weapon fall on the head.
Okay, so this amounts to a homicidal death.
Yes.
Right?
Yes.
So who are the witnesses? Two has stated nothing.
2 is the seizure witness, my lord.
Acha,
3
3
is also the disclosure witness. 3 is also hostile. 2 to 8 all are neighbor and co-villagers. 8
hostile.
all are hostile, my lord. 2 to 8.
Just a minute. 6 also did not support the prosecution case. The staying occurrence took place 2 to 3 months. Marriage of so and so. inquest.
2 and 3 also same in
ଛଡା
the seizure
କହୁଛି ଯେ ବାହାଘରଟା actually ଦେଖନ୍ତୁ
ବାହାଘରଟା
ବାହାଘରଟା ଆଷାଢ 2010 ରେ
evidence of PW9 से
ହଁ
10 ରେ लगा
ହଁ 2010 ରେ 7 ବି ସିଏ
ଆଷାଢ 14 ଡେ in the year of current
ହଁ ସେଇଥିପାଇଁ କହୁଛନ୍ତି ଯେ ବାହାଘର 5-6 ମାସ ପରେ ଘଟଣା ହେଲା। It's not 2009, same year.
Is your wife, her dead body was found in your house. What explanation have you given? ମିଛ କଥା
ସେ ଦେଇଛି ସେଇଟା ଯେ ମିଛ କଥା।
ଆଚ୍ଛା I heard that once you assaulted she was after purchasing କିଛି ନାହିଁ ବାକି ଆଉ 9 ଠୁ କଣ କହିଲେ କୁହନ୍ତୁ 8 ଠୁ 8 ତ ଯାଇ କିଛି ନାହିଁ।
ନ ହେଲା ଅଙ୍କଲ ତାର ସେ ଯୋଉ ସେ ଡାଉରୀ ଉପରେ କହିଛି।
କଣ ପଢନ୍ତୁ 2009 Dibakar Patra.
Dibakar Patra.
He was the uncle of the deceased.
I know the accused Surendra Das. I know the informant Amulya Patra, who is my nephew. Deceased Shraddhanjali is my niece. Shraddhanjali married to accused Surendra in the month of Ashada, 14th day in the year 2010. At the time of marriage, accused Surendra demanded cash of rupees 55,000, gold ornaments, gold chain, ring and other household articles. All the demand made by the accused was fulfilled by the informant in said marriage. After marriage, Shraddhanjali remained in the house of accused Surendra as his wife. After 20 to 25 days of marriage, deceased Shraddhanjali informed me over phone regarding the torture made by her father-in-law, sister-in-law, mother-in-law, both physically and mentally, demanding more dowry of cash of rupees 50,000. After hearing this, 10 to 15 days thereafter, I myself and informant and other members had gone to the house of accused, and there was discussion with the accused, his father, mother and other family members, and we had assured them to give rupees 50,000 after selling paddy after harvesting. After on 21/11/2010 at about 4 p.m. I got information over phone from villagers of accused Surendra that Shraddhanjali was killed by the accused. Thereafter, I myself, informant and other 5 to 6 villagers proceeded to the house of accused after hearing the news of death. The 3 we entered into the house of accused and found Shraddhanjali was lying on a cot in a pool of blood, and she was dead, and I found she had sustained injury on her head, and there was profuse bleeding on her head. Quite I asked the mother of accused, Surendra, who was sitting by a side of deceased, told us that accused her son assaulted to the head of Shraddhanjali by means of a crowbar. As a result, she died. Thereafter, I asked the informant to lodge FIR at the PS. Accordingly, the informant lodged FIR at the PS. Cross-examination by defense deferred cross-examination of PW9 Miller at 51 is 51. One Khaja Naik was the mediator from both the sides 7 to 8 days prior to marriage. a negotiation was held in our house. Sanatana Pradhan, Prafulla Patra, and others were present in said negotiation after marriage until the death of a deceased.
खजाना एक examine ही
Na.
पढ़ो
After marriage until the death of deceased, she had come to her father's house for about 3 times. I cannot say the exact date and time when I visited the house of accused persons. I cannot say the name of the persons who informed about the incident. I was present in the house of accused persons till arrival of the police. I have not seen the occurrence. Some neighbors of the accused near the house of accused, but I cannot say their names. I was asked by the police. It is not a fact that I had not stated before the police that this accused Surendra demanded cash of rupees 55,000, gold ornaments, ring, other household articles at the time of marriage, and that deceased Shraddhanjali informed me over phone regarding torture to her by her father-in-law, mother-in-law, sister-in-law in demanding more dowry of rupees 50,000, and that myself along with Pradipta informant and other members had gone to the house of accused and requested to grant to the accused his father, and had promised to pay the amount after harvesting, and that they had seen bleeding injury on the head of Sadanjali, and that the mother of accused Surendra, who stated before me that accused assaulted the head of the Shraddhanjali by means of a crowbar. As a result, he died.
Now we come to PW10.
My lord.
Well, you just, Mr. Naik, you just mark this lines in PW9's evidence. He is the uncle of the deceased. Paragraph number 2. After 20 to 25 days of the marriage, deceased Shraddhanjali informed me over phone regarding the torture by her father-in-law, sister-in-law, and mother-in-law. Both physically, it excludes the husband, right? And whatever information he has got on that particular day, it is stated by the mother of the petitioner has stated that he has assaulted. Obviously, mother has not been examined, so it is not his personal knowledge. It is heard from X, and X is neither an accused nor a witness in this case. Now, PW10, what he has stated.
I know the space 53. I know accused Surendra Das, and he is my brother-in-law. I am the informant of the case. This is Shraddhanjali Patra is my sister. He married to accused Surendra Das on 14th day of Asada 2010. As per Hindu rites and custom, after marriage, Shraddhanjali remained in her in-law's house. At the time of marriage, there was demand of dowry of rupees 55,000 by the accused and his family members, and the same was fulfilled, including gold ornaments, household articles too. After 1 month of the marriage, accused Surendra and his father and mother demanded more dowry of rupees 50,000. This matter was communicated by my deceased sister to me over mobile phone. Getting this, I myself, my uncle Dibakar Patra, and other 2 villagers went to the house of accused and requested the accused and his parents to fulfill the said demand after harvesting. After some days, the accused persons again tortured my sister, and my sister told me over phone as the said demand was not fulfilled. On 21/11/2010, I got a telephone call from an unknown person of village of accused that that the in-laws of my sister had killed her at 4 p.m. Getting this news, I myself and my uncle Dibakara proceeded to the house of accused Surendra and found my sister Shraddhanjali lying dead on a cot in a pool of blood. I saw deceased sustained bleeding injury on her head. While I asked the matter to the mother of accused, she told me that her son Surendra assaulted Shraddhanjali by means of a crowbar. Shraddhanjali resulting her death. Shraddhanjali resulting her death. Thereafter, I lodged FIR at Bansada PS Exhibit 6 is the said FIR and Exhibit 6 by 1 is my signature. I narrated the incident to my brother-in-law Mittubala and he wrote the FIR. Police seized some dowry articles from the house of the accused Surendra and gave the same in my Jima. Jimanama was prepared by the police. Exhibit 7 is the said Jima and Exhibit 7 by 1 is my sign. Cross-examination by defense. 1. Khajua Naik was the mediator in this marriage. Prior to 8 days of marriage, discussion was made in our house regarding marriage. Khajua Naik, Dibakara Patra, Surendra Patra, Rudra Biswala were present. Khajua finalized the demand of dowry. I cannot say in which company the accused was engaged. Accused, along with my sister, had been to our house only once after marriage, and at that time both accused and my sister were living happily. I cannot say the exact date, month when I visited to the house of accused. I cannot say the names of the nearby neighbors of accused. I had been to the house of accused with my uncle Dibakara and other Bhadraloks, but I cannot say the date and month. No meeting was held in the village of accused. After marriage, the accused had not gone to the service place till the death of my sister. I had given list of dowry articles to the police at PS. I cannot say the name of the persons who informed me regarding the death of my sister. The house of accused is a bamboo thatch. I had my uncle Dibakara had been to the house of accused. I saw my sister was lying dead on her bedroom on a palanka and I had presented that palanka. The palanka was bed covered with gaudy and bedsheet and we had presented the said gaudy and bedsheet at the uh, time of marriage. We gave two bedsheet to my sister when I went to the house of accused. Police was not present there. Police had given 54 items to me after seizure. We received the Palanka, Gadi and other articles from police on 22/11/2010 and we signed on the Jimanama. One almirah was there in the room made of iron plate. Whatever we received from the police as for Jimanama, we gave those articles to my sister out of love and affection. Prior to death of my sister, I had not made any complaint at the police station against the accused. I remained in the house of my sister till arrival of police. 7. I signed on some papers in presence of police. Whatever I stated before the police, it was reduced into writing. I signed on those papers. When I went to the place of occurrence, the parents of accused, his sister and other family members were present. the floor of the bedroom where my sister was living is made of soil. Rudra Viswala, my brother-in-law, is working as typist at Chandavali Tahsil. It is not a fact that I have not stated before the police nor mentioned in FIR that accused and his father demanded cash of rupees 55,000 and other articles at the time of marriage, and that after 1 month of the marriage, the accused and his parents again demanded 50,000, and that I myself and my uncle Dibakara Patra and two Vadraloks had gone to the house of accused to settle the matter, and that after settlement, the accused and his family members tortured my sister, and that on and that on 21/11/2010, Dibakara had been to the house of deceased with me, and that I saw my sister had sustained bleeding injury on her head, and that I asked the mother of accused, and she told me that accused assaulted my sister by means of a crowbar to her head. It is not a fact that accused had not made any demand of dowry and nor tortured my sister, and my sister died accordingly due to fall of bamboo from the roof.
Right, Mr. Nayak, you see from the very beginning, your case is that not only the husband, but the father, mother, brother, I'm to say younger brother, and also sister, they were torturing the deceased in connection with demand of dowry. And it is stated that obviously that they had killed the deceased in a general manner. They ସମସ୍ତେ तार परिवार सदस्य मिलित भाव शाबल पिटी पिटी मार जना right. Now this is lost by PW10, right? So what PW10 says that I got the information about the death from others. I came to the house of the appellant and found my sister there lying there. And I was informed, that is the evidence in during trial. I was informed by the mother of the accused that the accused
9 and 10. The three witnesses say that when I asked the mother of the deceased, the mother of the accused, they are saying that.
So if such an information was given, vital information was given to PW10, who is the informant in this case, prior to the lodging of the FIR, why she has not mentioned it in the FIR? Why she has stated that ଆମର ସନ୍ଦେହ ହଉଛି ଯେ ତାର ପରିବାର ଲୋକ ଏଇ ତାକୁ ମିଳିତ ଭାବରେ ପିଟି ପିଟି ମାରି ଦେଇଛି. So if such an information would have been given, ଯେ ତାକୁ ତା ସ୍ୱାମୀ ଶାବଳରେ ପିଟିକିନି ମାରିଦେଲା, ଏଇ information ଯଦି ଏତଲାକାରୀକୁ ଏତଲା ଦବା ପୂର୍ବରୁ ଦିଆଯାଇଥାନ୍ତା, ତାହେଲେ ଏତଲାରେ ଏଟା ମେନସନ ହେଇଥାନ୍ତା. ଏତଲାଟରେ ସେଟା ମେନସନ ହେଇନି, ଏତଲାରେ ମେନସନ ହେଇଛି ସମସ୍ତେ ତାଙ୍କୁ ମାରିଦେଲେ. So ବାକି now you come to the rest of the thing. Your case is that there was a demand by all, there was a torture by all. That is how the FIR was lodged against all the family members, including the husband. Now the police during the investigation did not find anything against any of the family members except the appellant, right? And that was not challenged also by anybody. Neither the state challenged the charge sheet, nor anybody, nor the informant side. And during trial also, you adduce such type of evidence. Some witnesses have stated that they were torturing in a general manner. right? And if all of them were torturing, according to you, in connection with demand of dowry, then how can you segregate the petitioner, the appellant, from others? Of course, there is no charge under 498A, no charge under DP Act, that's one matter. But the thing is that whether there was any demand of dowry at all, or not, because that is the reason that you say is the crux of the matter, or the main reason for which the deceased was killed within 5 to 6 months. But in the evidence, what has come from the informant's evidence, that whatever articles we gave to the deceased, we got back it in the Jimanama, right? And the important line here stated that whatever we received in the Jimanama has been given by us by way of presentation. That line is there, na? Just come to that. Page number 55.
We received the
Five lines from the bottom of that page. Whatever we received from the police as per Jimanama, we gave those articles to my sister out of love and affection. Where is the question of demand of dowry? So, jaha ame jimare pailu, segudaka amo bhauni ku ame amoro kusire amo bhalo paiba jogu ame deitilu. So those are not the articles demanded and given on the way of demand. So your base or the ground on which you are building up the case, that fails, because your ground is that there was a demand of dowry, it remained unfulfilled, and that was the reason for which the deceased was killed. But it has been elicited in the cross-examination that there was no demand of dowry. Whatever was given, it was out of love and affection. Number one. Number two, your initial case at the time of lodging of the affair, that ame sandeha karuchu samaste milimisi mar deichan sabolare piti piti. The informant now changed the version in the during trial, that I got the message or I got the information from the mother of the accused that it is the appellant who dealt crowbar blow to the deceased. So if such information was given to PW10 in presence of PW9 and others, and thereafter the FIR was lodged, certainly this thing would have been there in the first information report. So absence of such material thing in the FIR shows that this was a subsequent development. These things have been concocted afterwards. Initially, you are not aware who had how the deceased died. So that is why, in a general manner, you have implicated. And had it been a case that there would not have been any other family members there in that house, suppose let us say in a house only husband and wife were residing, and the husband, the wife died, and that to a homicidal death. Obviously, the husband is bound to explain under section 106 of the Evidence Act. Burden of proof shifts to him. But there are other family members also. Father, mother, younger brother, sister, all of them were, and against all you have made allegation. So how do you say that even if the husband says that taken a plea of denial totally, how do you say that what are the evidence adduced by you, cogent evidence, from which it can be said that the husband is the author of the crime? He has killed his wife. On what basis? No direct evidence. No direct evidence. Case based on circumstantial evidence. Circumstantial evidence in which motive assumes an important factor, and your motive in this case is that for non-payment of demand of dowry, there was torture, and for that reason, the deceased was killed. But we find that there was no demand of dowry, rather whatever articles were given, it was out of love and affection. Right? So motive fails. Now the thing is that what are the rest of the material? The rest of the material indicates that it was in a general manner the allegations has been made. And even one witness, that PW9, he has stated that page number, he stated that when he talked with the deceased over phone, he come to that line, paragraph PW9, 50 page number 49. After 22, paragraph 2, after 20 to 25 days of marriage, the deceased Shraddhanjali informed me. Did you get it? Over phone regarding the torture made by her father-in-law, sister-in-law, mother-in-law, both physically and so here he omits husband. So this would have been also a relevant feature that even if the law has gone to the extent that such type of statement can be also accepted as dying declaration if it has got any relevancy with the cause of death. A deceased is informing our in-laws family members that these are the person who are torturing me, and thereafter he is died a unnatural death. So that has also got some relevancy that led to the transaction how the death took place. But here he is excluding the husband and the persons whom she has implicated, father-in-law, mother-in-law, and sister-in-law. They are not the accused persons in this case, right? Now, another thing you see that the brother has stated, page number 55, we see also placed paragraph number 5. Accused along with my sister had been to our house only once after marriage, and at that time the accused and my sister were living happily. So they were living happily. It is the brother statement, informant statement, and whatever information has been given to PW9, that was against the other accused person, other persons who are not the accused in this case, right? And the articles given was out of love and affection. And 4 persons are there, 5 persons, including the appellant, 5 persons are there in the house. They are not the accused. So how can you say that this man is the author of the crime? On what basis?
Have you examined mother of the
No, mother.
mother?
Mother is not.
Mother said that
Mother of the accused.
No, mother said, but mother of the accused, have you examined?
No, she has not examined.
Why not? Any explanation given? Have you declined her or she died?
Mother, because
Pilot
mother
at the case of
accused ma examine ହେଇଥିଲେ ତାକୁ support କରିଥାନ୍ତା
ଏଇ କେସଟା ଯେହେତୁ ରେଜିଷ୍ଟର୍ଡ ହେଇଥିଲା 498 ରେ ସେମାନେ ଆକ୍ୟୁଜ୍ଡ ହେଇଗଲେ ତେଣୁ ଇଏ ଆଉ ତାଙ୍କର ଇଏ ନେଲାନି ତାଙ୍କର ରେକର୍ଡ କଲାନି ଷ୍ଟେଟମେଣ୍ଟ
ଘରେ ଜଣେ ଯେତେବେଳେ 5ଟା ଲୋକ ରହୁଛନ୍ତି
ତାର
ଡେଥଟା
ଷ୍ଟେଟମେଣ୍ଟ
ହେଇଛି homicidal death, if you are not making all of them as accused and only making an accused against X ଗୋଟେ ଲୋକ ନାଁରେ ଆପଣ ମାନଙ୍କୁ କୋଜେଣ୍ଟ ଏଭିଡେନ୍ସ ଲିଡ୍ କରିବାକୁ ପଡିବ ଯେ କେମିତି ସେ ଲୋକଟା ଏଇ ଯୋଉ 5 ଜଣ ତ ଥିଲେ ସେ ଘରେ ଏଇ ଲୋକଟା କେମିତି କଲା ତେଣୁ ଆପଣ ସେ କିଛି ଏଭିଡେନ୍ସ ଆଣିନା ଆପଣ ସାଟିସ୍ଫାଇ ହେଇଗଲେ ଯେ ଯେହେତୁ ଗୋଟେ ଏଭିଡେନ୍ସ ଲିଡ୍ କରିଗଲା ଯେ ତା ମା କହିଲା ଆକ୍ୟୁଜ୍ଡ ର ମା କହିଲା ଯେ ସେ ସ୍ୱାମୀ ତାକୁ ଶାବଳରେ ମାରିଲା ସେଇ ଲୋକ ଯିଏକି ଏତଲା ଦେଇଛି ସିଏ ସେ ବିଷୟରେ ଏତଲାରେ ଉଲ୍ଲେଖ କଲାନି ରାଦର ସେ କହିଲା ସମସ୍ତେ ତାକୁ ଶାବଳରେ ପିଟି ମାରି ଦେଇଛନ୍ତି ତେଣୁ ଏଇ ଯୋଉ ସ୍ୱାମୀ ଶାବଳରେ ପିଟିକିନି ମାରିଲା ଯୋଉଟା କି ତା ମାଠୁ ଶୁଣିଲା this is an afterthought one. Otherwise it would have been, it is conspicuous by the absence, it is very much relevant under section 11 of the Evidence Act. So how do you say ଏଇ ଯୋଉ ଜିନିଷଟାକୁ ଯଦି କୁହା ହେଇଥାନ୍ତା ସେ ନିଶ୍ଚୟ ମେନସନ କରିଥାନ୍ତା ଏତଲାରେ ସେ ଛାଡି ନଥାନ୍ତା ତା ଭାଇ ଏତଲା ଦଉଛି ତାକୁ ଯଦି ଏଇଆ କଥା ସେ ଇନଫର୍ମେସନ ପାଇଥାନ୍ତା ସେ ଲେଖିଥାନ୍ତା ମୁଁ ଯାଇଥିଲି ଏବଂ ତାର ଶାଶୁ ମତେ କହିଲା ଯେ ତା ସ୍ୱାମୀ ତାକୁ ଶାବଳରେ ପିଟିକିନି ମାରି ଦେଇଛି ଏ କଥା ନିଶ୍ଚିତ ଲେଖିଥାନ୍ତା, ଲେଖିନି ଯେହେତୁ ଏବଂ ସେ ଲେଖିଛି କଣ ନା ସନ୍ଦେହ ହଉଛି ଯେ ତାର ଭଉଣୀର ଶାଶୁ, ଶ୍ୱଶୁର, ନଣନ୍ଦ, ଦିଅର ଏମାନେ ସମସ୍ତେ ମିଳିତ ଭାବରେ ଶାବଳରେ ପିଟି ପିଟି ମାରିଥିବାର ଜଣା।
After death of her sister, ସମସ୍ତଙ୍କୁ entangle କରିବା ପାଇଁ right.
No, that is why, how do you say that in this circumstance we can say with certainty that he is the author of the crime?
That part, my lord, another part, my lord, so the.
Are you prepared or not? I am
Yes,
खाली ये करना है.
As per the doctor examination report.
No, let us say it is a homicidal death. We are not.
And that is in that that's the backside of the head, that the occipital, that meaning that is the occipital.
ଯାଇଛି summons. To compound এটা ହେଇଛି ସେଇଟା ହଉଛି
Laceral wound over the left of the shirt.
left କାନ ନେ examine ହେଇନି.
Examine.
କିନ୍ତୁ ଯାଇଛି summons.
See.
No, maybe.
No, he is must have been witness also. Charge sheet witness थियो. से तो पढ़ना थियो. ऐसे मना करथियो public prosecutor decline कर दी.
ସେଟା ପଢିଲେ ପାଉନି.
ଏ ଗୋଟେ memo ଦେଇ ଦିଅନ୍ତି ଯେ to decline.
ସେଇଟା ମୁଁ ଖୋଜୁଥିଲି decline ହେଇଛି ନା ମରି ଫରି ଯାଇଛି.
ନାଇଁ decline कर ଦେଇଥିବେ କି ଯଦି ଆସିଥିବ. trial court report है.
अच्छी तरह से दर्द देखिए. Someone says he was there.
The ଗୋଟେ ସାଇଡ ରେ ହଉଛି ଆପଣଙ୍କର ଯେ ଗୋଟେ heinousness crime, very, but again the law is that higher the often than the heinous the offense, and the higher must be the proof. ଆପଣ ଯେତେ serious offense ଆଣିବେ ଆପଣଙ୍କର proof ର ମଧ୍ୟ standard ସେଇ type ର ରହିବା ଦରକାର. ଜଣେ ଲୋକକୁ ଆପଣ life imprisonment ଦଉଛନ୍ତି, ଗୋଟେ ଲୋକଙ୍କ ଘରେ 5ଟା ଲୋକ ରହିଛନ୍ତି, ତା ଦେହରୁ ଆଟଲିଷ୍ଟ 3ଟା ପୁରୁଷ, ୟାକୁ ଛାଡି ଆଉ 2 ଜଣ ପୁରୁଷ ଲୋକ ଅଛନ୍ତି, ତା ବାପା, ତା ସାନ ଭାଇ, ଏବଂ ଆପଣ ପ୍ରଥମ ଷ୍ଟୋରି ଆପଣଙ୍କର ହଉଛି ଯେ 5 ଜଣ ଯାକ ଆମେ ତାଙ୍କୁ ମାରି ଦେଇଛନ୍ତି ବୋଲି ଆମେ ସାବଳରେ ସନ୍ଦେହ କରୁଛୁ. ଆପଣ ସେଇ ଯୋଉ କଥାକୁ ପୁରା ଟୋଟାଲ ଛାଡିଦେଲେ, ନେଇ ଆସିଲେ ଗୋଟେ ନୂଆ ଷ୍ଟୋରି ଯେ ତାକୁ ସାବଳରେ ତା ମା କହିଲା ଯେ this is a new type of story to develop.
Fact, as per the doctor report, that is the injury number 2, so the injury 2 is concerned, lacerated wound over the left occipital slab. The occipital slab is the back side of the head. I find it that is the back side of the back side of the munduk. Compound fracture in the left occipital. That is the injury number 3.
कौन पे हो जल्दी?
No, why are you rightly? Why so question is that we are suppose let us say that is not disputed. It is not disputed that the death has taken place in the house of the accused, and the death has taken place. It's a homicidal death, and the cause of death is also due to assault on the head, and that assault was made also by crowbar. All these things are there, but again you have to prove that who has dealt that assault. If it would have been a single man residing there, matter is different. But when so many persons are there and you are trying to implicate all the persons in the assault of the deceased, now in the trial you are segregating it and creating a new story that we got the information from the mother that his son has killed, whereas the evidence indicates that they were living happily, there was no demand. So you have not prepared. We are giving another chance. Just go through it and take up on Monday. Hello? Leave it. To find out those decisions, some decisions you may get also. This type of evidence which he has given is a hearsay one.
Right.
Suppose he has heard it from the mother, his witnesses. So, in order to be admissible, the mother should be examined.
Yes.
Once the mother is not examined, it becomes hearsay. Hala? ମୁଁ ଯଦି କହିବି ମୁଁ ଏ ଘଟଣାଟା X ଟୁ ଶୁଣିଲି, X ମତେ କହୁଥିଲା ଏ କଥା, ଯଦି X examine ହବନି ଏଟା ହେଇଗଲା hearsay.
That was reflected in the judgment, Lord.
Right. That is the
The
fundamental
bottom.
section 60 of the Evidence Act. It says about that the hearsay evidence is not admissible. ତେଣୁ ଯାହାଠୁ ଶୁଣିଲି ସେ ଲୋକଟାକୁ ଏକ୍ସାମିନ ହବା ଦରକାର ହେଲା ସିଏ ଯଦି ନ ଶୁଣିଲି ମୋର ବ୍ୟକ୍ତିଗତ ଜ୍ଞାନ ନାହିଁ ସେ ଲୋକଟାର ଜ୍ଞାନ ହୁଏତ ଥାଇପାରେ ତାଠୁ ମୁଁ ଶୁଣିଛି ତେଣୁ ସେ ଲୋକ ଯଦି ନହେଲା ଏଟା ଶୁଣା କଥା ହେଇଗଲା ହେଲା ତେଣୁ ଏଠି mother has not been examined. Mother summons issue ହେଇଛି, summon he has not been examined.
And also the report of the chemical examination
So
was
two things
not
are there, Mr. Nayak. One thing is that this evidence becomes an hearsay one, right? In absence of the examination of the mother. Second thing, that mother has made such a disclosure is highly doubtful because it is not mentioned in the first information. ये যদি एतलाकारी ए टाइप रो गोटे सेक्शन 11 रे गोटे डिसीजन अछि 1975 सुप्रीम कोर्ट रे हला सेक्शन 11 पर जस्ट ए टाइप रो एतलाकारी गोटे इंपोर्टेंट जिंस सुनिछि एवं से सेटा को मेंशन करनी एतला रे एटी से कहउछंती जदी एतलाकारी को पाखरे ए इंफॉर्मेशन थिला बा सी विषय जानि थिले एतला देले सेटा को निश्चय मेंशन करथांते Jadi mention karnati, its absence is very relevant under section 11 of the Evidence Act, 1975 Supreme. Hala? Tenu ethi ମାଠୁ ଶୁଣିଲା ତା ମା କହିଲା ଦିଟା ଜିନିଷ ଯୋଗୁ ଡାଉଟଫୁଲ ହଉଛି ଗୋଟେ ହଉଛି ତ ହିୟର୍ସ ଏଭିଡେନ୍ସ ହେଲା ଦ୍ୱିତୀୟ ଜିନିଷଟା ହଉଛି ଯେ ଏତଲାକାରୀ ତାକୁ ଏତଲାରେ ଉଲ୍ଲେଖ କରିନି ରାଦର ସେ ମେନସନ କରିଛି ଆମେ ସନ୍ଦେହ କରୁଛୁ ସମସ୍ତେ ତାକୁ ପିଟି ପିଟି ଶାବଳରେ ମାରି right this creates doubt so please go through it once again and find out those reasons. That's all.
Sir.
ଆପଣଙ୍କର କେତେ ନମ୍ବର
20 Monday
ତାପରେ ନବା ଆର ସପ୍ତାହରେ ଏଇଟା ଫାଷ୍ଟ ନେଲା ପରେ
Mr. Panda କୁଆଡେ ଗଲେ
ପଣ୍ଡାଙ୍କର
ପଳେଇଲେ
already next week
ଦେଖୁଥିଲି ପରା ଗୋଟେ କାହାକୁ ୱାରେଣ୍ଟ ହେଇଛି ତାକୁ କଣ ହେଇଛି
he must be the man କଣ କହିଲେ
ମଲ୍ଲି ଦାସ
he must be a charge sheet witness final form ବାକ
ସମନ୍ସ ଯାଇଛି ନା
final form ରେ the list of witnesses ଥିବ ତା ନା ମଲ୍ଲି ଦାସ ତ ମଲ୍ଲି ଦାସ ଲେଖା ହେଇଛି it is number 5 final form
ସମନ୍ସ କରାଯାଇଛି
ତମର decline ହେଇଛି ପୁରା ଲେଖା ହେଇଛି ଉପରେ ଏଠି ଛକି ମରା ହେଇଛି
ଲେଖା ହେଇଛି
ଏଇଠି
ସମନ୍ସ କାହିଁ ଗଲା ତାହେଲେ
ନାଇଁ ଆସିଲା ପରେ ତାକୁ ଟେଷ୍ଟ କରିଥିବ ପବ୍ଲିକ ପ୍ରୋସିକ୍ୟୁଟର
ତାପରେ ଡିକ୍ଲାଇନ୍ ଡେଟ୍ ଅଛି
ହଁ ଲେଖା ହେଇଛି 31/10 ଡିକ୍ଲାଇନ୍ ହେଇଛି
ତାହେଲେ ତ ମିଳିଯିବ 31/10/2000
ସେଇ ଯେବେ ହେଇଥିବ ସେଇ ପାଖାପାଖି 31/10 ମାନେ ସେଇଟା ହେଲେ ଗୋଟେ ହଁ ଦିଟା ୱିଟନେସ୍ କୁ ଡିକ୍ଲାଇନ୍ ଲେଖା ହେଇଛି one is CW5 the other is CW9 charge sheet witness number 9 ଖଜୁଲା ନାୟକ ସେଟା ହଉଛି ସେ ମଧ୍ୟସ୍ଥି ଖଜୁଲା ମଧ୍ୟସ୍ଥି କୁ ଡିକ୍ଲାଇନ୍ କରିଛନ୍ତି ଆଉ ତା ମା ଟାକୁ ବି ଡିକ୍ଲାଇନ୍ କରିଦେଇଛି ମଲ୍ଲି ଦାସ
କିନ୍ତୁ ସେ 31/10
ଏଇଟା ଦିଟା ଗୋଟେ ଡେଟ୍ ରେ ଡିକ୍ଲାଇନ୍ ହେଇଛି ଦିଟା 31/10 31/10 ମାନେ ଇୟର ଟା ଲେଖା ହେଇନି ଜଣା ପଡିଯିବ ସେ ଏ ଯୋଉ ଆମର Maybe the evidence के भी record अलग है 3110 ना मैंने
2011 स्टार्ट है जी
से 2010 11 31
डेट ही नहीं
31/10/2011 देखिए
ଏ ପେଜଟା କି ଚିରି ଦେଇଛି ଗୋଟେ ଅଛି 15/7 ତାପରେ
no 31
ତାପରେ ପେଜ
it will be found
ଏ ପେଜଟା
last witness let us see last witness ଟା ହେଇଛି ଆମର PW କେତେ 12
12 ନାଇଁ
PW 12 ଟା କେବେ ହେଇଛି ଦେଖୁନାହାନ୍ତି
15/7 ରେ ଗୋଟେ ମୁଁ ଅର୍ଡର ସିଟ୍ ଦେଖିଛି 15/7 ରେ ଗୋଟେ ଡେଟ୍ ହେଲା
no you just come to PW 12 examine କେବେ ହେଲା 12 ମାର୍ଚ୍ଚ ନାହିଁ ତାପରେ
ଲାଷ୍ଟ ହଉଛି ତାର 19/5/2012
PW अच्छा এটা just हाँ बुझିନ PW 11 ହେଲା 31/10/2011
12
2011
11 ପୁରା ହେଇନା
हाँ 2011
11 ପୁରା କିଛି ନାହିଁ
no shit
15/7/2011 ରେ
trial court record हवा
हाँ से ट्रायल कोर्ट रिकॉर्ड 15/7/2011 accused produced in custody that is page 4 of the LCR मतलब 17 मार्च 2012 रे जो आईओ एग्जामिन ହେଇଛି witness 12
ତା ପୂର୍ବରୁ decline ହେଇଛି
15/7/2011 ପରେ ଡେଟ୍ ଟା ଫିକ୍ସ ହେଇଛି এটা ପେଜ ଚିରି ଗଲା
ଏଟା ଚିରି ଯାଇଛି ଏଟା ଦେଖନ୍ତୁ 1/10/2011 ଅର୍ଡର ସିଟ୍ କରିଛନ୍ତି
1/10
1/10/2011 ପରେ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ ଅପ୍ ହେଇଛି colon 31/10/2011 ସେ 31/10/2011 ଅର୍ଡର ସିଟ୍
ଆପଣ ଏଟା କୋଟା ଦେଖୁଛନ୍ତି
ଏଇଟା ଅର୍ଡର ସିଟ୍ ଏଇ ଅର୍ଡର ସିଟ୍ ଏଇଟା 1/10/2011 ଏଇଟା
ପେଜ 9 ତାହେଲେ ସେ ଆଗ ପଛ ଇଏ କରିଦେଇଛନ୍ତି
UTP 1/10/2011 ସୁଆଂଶୁ colon 31/10/2011 ହେଲା 31/10/2011 ଅର୍ଡର ସିଟ୍ ଟା ଏଠି କୋଉଠି ମିସ୍ କରୁଛି ଏଇ ଦିନ ଡିକ୍ଲାଇନ୍ ହେଇଛି ଏଟା ଡେଟ୍ ପଳେଇ ଅଛି ତାପରେ 3/12/2012 I do not know
କୁଆଡେ ଗଲା ସେ ଡେଟ୍ ଏକା ଷ୍ଟ୍ରେଞ୍ଜ
ସେଇ ଡେଟ୍ ରେ ଡିକ୍ଲାଇନ୍ ହେଇଛି ଦି ଜଣଙ୍କୁ
ଭେରି ଷ୍ଟ୍ରେଞ୍ଜ ସେ ଡେଟ୍ ଅର୍ଡର ସିଟ୍ ତ ନାହିଁ
ଅର୍ଡର ସିଟ୍ କୁଆଡେ ମିସ୍ କରୁଛି
ଆହୁରି କେତେଟା ଅର୍ଡର ସିଟ୍ ବାହାରିଛି
ନାଇଁ
3/9/2011 ସ୍କାନ ହେଇକି ଅଛି
ନାଇଁ ସେଗୁଡା ନାହିଁ ଏଇ ଡେଟ୍ ପରେ ସେଗୁଡା ସବୁ ସିଭିଲ୍ ହେଇକିନା ଅଛି
15/9 ହେଲା 1/10 ହେଲା 1/10 ପରେ 3/2/12 ତ ଆଗରୁ ଆଉ କେତେ ଅର୍ଡର ଅଛି
ଆରି ପର ଯୋଉ ଡେଟ୍ ଟା ସେଇ ଦିନ ଡିକ୍ଲାଇନ୍ ହେଇଛି ଏଇ ଦିନଟା 31/2011 ଡିକ୍ଲାଇନ୍ ହେଇଛି କାରଣ ଏଠି ଲେଖା ହେଇଛି ମଧ୍ୟ
ଏଇଠି ଦେଖନ୍ତୁ ଏଇଠି ଆସିଲା ତା ପୂର୍ବରୁ ଅଛି এটা 17/8 ନା ଏଟା ତ ପର ଡେଟ୍ ଗୁଡା
ଆଚ୍ଛା
ଏଟା କେତେ
अच्छा ये अच्छी आगे पीछे कर दी UTP not produced today police answers engagement PW 10 and 11 are examined cross examined answer एगुड़ा तो मार्क एगला एग्जिबिट गुड़ा को one memo has been filed by the APP files a memo that except the IO he does not want to no other witness be examined in this case this is a decline ये memo ta
ଯୋଉଟା ଡେଟ୍ ନାହିଁ ସେଇ ଡେଟ୍ ଟା ଅଛି ପେଜ
31/10
page 4 ବୋଧେ
31/10/20 2011
हाँ हाँ
2011 order of accused and mediator decline କ୍ଷୀର ଦିଆଗଲା ଦୁଇଟା ଏକ୍ସାମିନ୍
ସେମାନେ ଏକ୍ସାମିନ୍ ହେଲେ
ତାପରେ ଆଉ ଦେଇଦେଇଛୁ ଆଉ।
clearly 110 वाला 31
ଏଇଗୁଡ଼ା ଏଇଟା ବେଶୀ ଦିଆଗଲା ଏ ଦୁଇଟାକୁ ଏକ୍ସାମିନ୍ ହେଲେ ସେଦିନ
ତମ ପାଇଁ not to
ଫାଇଲ୍ କରିଛି ଯୋଉଟା ପରେ ଗଲା ସେ ଏପଟ ସେପଟ କରିଦେଲା ବେଳକୁ କେମିତି ଆମେ ଟିକେ ଖୋଜିକି ପାଇଲୁ।
ତାପରେ ଆମ ସ୍କାନ କରିଛନ୍ତି ସେ ପେଜ ଟା ପଡିଯାଇଛି ତା ଡେଟ୍ ଟା ଜଣା ପଡୁଛି ନାହିଁ ଅର୍ଡର ସିଟ୍
ମେନସନ୍ ଥିବ ସେ
ହାଜିରା ଗୁଡା ପପୁଲାର ହାଜିରା ନା
ଯଦି ସିରିଏଲି କରନ୍ତି
ସିରିଏଲ ଥିଲା ଏତିକି ସିରିଏଲ ଥିଲା ଏଇଟା ତ ଏଲସିଆର ଟା ଅଛି ନା ନା ସେଇଟା ମିସିଂ এটা ডেট এটা additional section এটা NBW ইস্যু হয়েছিল ওটা দিব্যাকর পাত্র জনা পড়ে 15/7 তো তারপরে থাকে 15/7 page 55 LCR এটা হচ্ছে
55 লিখলে চলে এইটা substitution is 55 order stated 3110
here page 61 पर 206 06 55 thank you 06 06 on a running page of the LCR the digital page so जो 55 लिख ले the side में 66 लिख दो
55
हाँ that side में लिख दो होगा नाम digital page 6
yeah এটা নিয়ে
এটা ওটা ফ্ল্যাগ মার্ক তো করলে এটা রেকর্ড